All right, thank you all for being here. Sorry, we're running just a little bit late. Just left the House floor. Members, let's go ahead and get signed in. And Madam Clerk, if you go ahead and open the board for a roll call. One roll. Representative Garrett. Very good. All right, Madam Clerk, you can take the roll.
Mr. Chair, you have 13 members present. You have a quorum.
Thank you. Okay, members, anybody have any announcement or personal orders before we get started? Representative Ashley, you're recognized.
Thank you, Mr. Chairman. I'd like to recognize a few people from Sevier County here today. Chief Catlett, Chief Barrett, and Chief Smith, and are good friends of mine. I've known Chief Smith since I've been about 8 years old. Used to pastor him in the police department. Then we loaned him out to Oak Ridge, I guess, and Scarborough's got him. So welcome here today.
Representative Scarborough, you're recognized, sir.
I'm going to pile on Representative Ashley's comments. We have many police chiefs friends here today, and we appreciate you making an effort to come down, and it's great to look out there and see you here. Thanks for being here.
Members, anything else before we get started on our calendar? All right, seeing none. Let's, if we could, without objection, let's move to item 33. Chairman Howell, sir. House Bill 785, members. You got a motion, members, and second. And then look like House Amendment 6583, members. And you got a motion and a second there. We need to go ahead and adopt that, Chairman Howell?
Yes, please.
Members, any objection to adopting the House Amendment 6583 to House Bill 785? Seeing none, all in favor say aye. Aye. Opposed? No. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Chairman and members. This bill is a reporting bill designed to ensure that bail bonding companies are not overextended on the amount of bonds that they are approved for. Under current law, the bail bonding industry self-reports. However, a bondsman may be licensed to do business in 1, 2, 3, 4 counties. However, a judge in one county may not have the information of how much money that bonding company is obligated for in another county. This bill is designed to correct that by requiring that a quarterly report be filed with the county court clerk. Also, every bond that's written has a $12 fee, which is to be submitted to the Department of Revenue. That's current law. This bill creates an audit process then and gives revenue, working with the information from the court clerks, the ability to determine if a bondsman is overextended and paying the $12 fee. With that, Mr. Chairman, I would ask passage.
Thank you, Chairman Howell. I have Ron Travis, or Representative Travis, you're on the list first.
Thank you, Mr. Chairman. Question on the bill.
Question's been called. Any objection? Seeing none, members, looks like we're ready to vote. Send House Bill 785 and as amended to calendar rules. All those in favor vote aye. Those opposed vote no. Has every member voted? Anyone like to change their vote? All right, Madam Clerk, if you take the vote. Thank you.
Mr. Chair, you have 14 ayes, 1 no, and 1 present not voting.
Very good. House Bill 785 as amended is moving to calendar rules. Thank you.
Thank you, Mr. Chairman. Come in.
And members, we could move back up the calendar. Item 18, House Bill 1010. Chair Lady Moody. Ma'am, you got a motion and a second. I don't see any amendments. You're probably recognized.
Thank you so much, committee. The current law provides a process in which a person holding any public office can be removed. Currently, only the state attorney general, district attorney generals, and county attorneys and city attorneys within the respective jurisdictions may institute such actions. And this has proven to be an issue in some cases where the locally elected district attorney recuses themselves to avoid potential conflicts of interest. This bill will simply add language to explicitly allow a district attorney general to appoint another district attorney general or an assistant to that DA to conduct the removal actions.
Very good, and thank you for that explanation. Members, any questions for Chair Lady Moody? Representative Hardaway, you're recognized.
Thank you, Chairman, and good morning to the Chair Lady.
Thank you. Good morning.
What's the genesis of this bill?
There have been let me see if I can find anything. There have been just a few instances of this recusing and then no action being able to be taken.
Representative Hardaway.
And thank you, Chairman. This was initiated by the DA's conference or the AG or?
Chair Lady.
You know, I don't have that information.
Okay. All right,
I
I'll
would
get
be
with you
guessing.
later,
I'm
Chair
sorry.
Lady. Thank you, ma'am.
I'm sorry. Thank you.
Very good. Chair Lady Littleton, you recognize.
Thank you, Mr. Chairman. Move for previous question.
Members, proper motion. Any objection? Seeing none. Looks like we're voting to send House Bill 1010 to calendar and rules. All those in favor, vote aye. Opposed, vote no. Has everyone voted? Anybody like to change the vote?
When I-
All right. Madam Clerk, if you would please take the vote.
Mr. Chair, you have 16 ayes, 3 noes, and 0 present not voting.
Very good. House Bill 1010 is moving to
Thank you,
Calendar rules.
committee. Thank you so much.
as amended. Members, we could move to, once again, move down the calendar, item 34. That's House Bill 1204. Chairman Kumar? So we got a motion and a second. I see House Amendment 6612. Would you like to adopt that amendment?
Yes, Mr. Chairman.
Members? Any objection to adopting House Amendment 6612 to House Bill 1204? All right, seeing none. All in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized.
Thank you, Mr. Chairman and committee. House Bill 1204 does three things. Firstly, the situation is that under current working law, if a person who has been arrested for a DUI refuses to submit to blood test, the law enforcement is supposed to be helpful by using reasonable force to restrain them so a blood sample can be obtained. Reasonable force is a slippery slope. And my assistant police chief suggested that we just add 6 months more to the period of license suspension so that officers don't have to struggle with it. So that is one thing that this bill does. Secondly, it adds the new technology of oral fluid testing that can be performed at the site and gives information not only about alcohol, but other substances that may be in consideration for the DUI. And thirdly, it corrects an inversion of sentencing that has occurred over the period of years. We've been increasing sentences for DUI, and it turns out that at this time, after the third conviction, the sentence recommendation for DUI is higher than vehicular assault. So that inversion is being corrected. Mr. Chairman, I do have people from the DA's General Conference in case we want them to testify.
Thank you for that. Members, do we have any questions for Chairman Kumar on the bill? Representative Johnson, you're recognized.
Yes, I guess we know that medical restraint is different from restraints that police officers do or that they do in schools. Are these police going to be trained in medical restraint? Are they going to be experts in medical restraint?
Chairman Kumar?
Actually, we are eliminating the need for restraint and holding people down to draw a blood sample. We are saying that if a person refuses to submit to blood test, instead of a 1-year suspension for DUI, the suspension period of the license will go to 18 months.
Okay, so you're not saying that police officers will be used to help obtain that sample?
Chairman?
That is true.
Thank you.
Members, any additional questions for Chairman Kumar? Representative Hardaway, you're recognized.
Thank you, Chairman. And for some reason, I can't pull up the bills on my iPad, so I'm going to have to ask more questions than
It should
I
be on
normally would.
yesterday's. We're working off the same calendar as yesterday, so you may have to go to Tuesday's calendar, pull it up, and it's item 34.
Okay. All right. So, sponsor, In terms of the penalty, I understand that the additional 6 months. Is that correct?
Chairman
That's-
Kimmer?
That is true.
And that's if the individual is found guilty of DUI, or is that the penalty for refusal?
Go ahead.
That's the penalty for refusal, but of course it will be, they would be found guilty of DUI, and then this would be an added penalty.
Representative Harley, any follow-up?
Yeah, let me make sure I'm clear, because I'm not going to support anything that penalizes the refusal. So you're saying if they're found innocent, they would still get a suspension based upon their refusal?
Chairman Kumar?
No, sir. If they are innocent, they are innocent.
Okay, and everything's wiped clean, no additional penalties for the refusal to take the test. All right, I'm good.
Very good. Any additional questions? I have Representative Travis, you're next on the list.
Thank you, Mr. Chairman. I call previous question.
Very good. Any objection? Previous question has been called. Let's see. Objection. Members, there's objection. We're going to be on the board. All those in favor of previous questions, vote aye. Opposed, vote no. Madam Clerk, you take the vote.
Mr. Chair, you have 14 ayes, 6 noes, and 0 present not voting.
All right, previous question prevails. Members are going to be voting to send House Bill 1204 as amended to Finance, Ways and Means. All those in favor vote aye. Those opposed vote no. Has that been voted? Does anybody need to change the vote? Madam Clerk, if you take the vote.
Mr. Chair, you have 14 ayes, 5 noes, and 1 present not voting.
Very good. House Bill 1204 as amended is moving to Finance, Ways and Means.
Thank you, Mr. Chairman and
Thank you.
committee.
All right, members, if we could just move down to item 35, the very next item on the calendar. Chairman Grills, House Bill 1189. Well, let's see. Chairman, did you want to roll that to today's calendar?
That's fine.
Very good. And you also have another bill. So without objection, item 35, House Bill 1189 is to be rolled to the Hill of today's calendar. Looks like you also have item 45, members. Without objection, if we can move to item 45. That's House Bill 811. You have a motion and a second on the bill. Members, we have House Amendment 3769. And you have a motion and a second on that. Is that an amendment we need to adopt, Mr. Chairman?
Yes, sir.
Okay, very good. Members, any objection to adopting House Amendment 3769 to House Bill 811? All right, seeing none, all in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bills amended. You're properly recognized.
Thank you, Mr. Chairman and committee. It's good to see y'all once again today. We had a marathon yesterday, so I kind of like this committee, I guess. This is a public safety bill working with the President Trump's administration on his renewed focus on illegal immigration. And what we're doing with this bill is anyone who is a victim of crime committed by an illegal alien will have a private right of action against any NGO that has assisted the illegal alien with the housing in the community. And that housing would be defined as long-term living accommodations or a rental home, and includes assistance with obtaining or signing a lease for an apartment or for a rental home. This does not impact temporary housing, overnight housing, homeless shelters, women's shelters, Red Cross, and those types of activities.
Very good. Members, do we have any questions? We do have an individual that signed up to speak on this bill. Sorry. Have Ms. Cranks. Ma'am, are you here? Members, any objection going on a session here from Ms. Cranks? Not seeing none. Thank you for being here. If you just have a seat up there, take any seat you'd like. Matter of fact, we'll make sure your microphone's on. If you just introduce yourself, and you have 2 minutes.
Thank you, Chairman and members of the committee. My name is Lindsay Crinks, and I've worked on issues of homelessness in Tennessee for almost 20 years. I'm a minister and a co-founder of a faith-based homeless outreach nonprofit that's housed over 1,000 people since our inception. And I'm also the co-founder of a statewide coalition on housing and homelessness. I'm here today representing dozens of nonprofits, charitable organizations, and faith-based nonprofits across our state who are deeply concerned about this bill. We're grateful that temporary and emergency shelters were removed from the language of this bill, but we still have a lot of deep concerns. You see, our goal is not just to provide shelter to people, but it's also to connect people with permanent housing in order to break cycles of homelessness. So we help people obtain and sign leases, just like this bill says. We work with everyone we can who comes to us seeking care and a better life. We're not political groups. We're people who are living out our faith and carrying out our mission. We're concerned that this bill is still too vague when it comes to defining negligence, and we're concerned that this bill will inhibit our religious freedom. As a minister and nonprofit leader, I believe that every person, regardless of their immigration status, is a child of God who deserves dignified housing. When we push for policies and use language that dehumanizes our neighbors from different countries, we're defiling the image of God. People of faith are bound first to our sacred texts. My directives from the Bible include to love and welcome the stranger, and as Zechariah says, to show kindness and mercy to one another and not to oppress the widow, orphan, and foreigner or the poor. I've worked with people from all backgrounds and all immigration statuses who have worked hard, who have paid their taxes and tried their best to find a legal pathway to citizenship, many of whom came in their youth to this country. I've seen them struggle as they're denied care, services, and programs that their tax dollars fund and that people with documents can access. I do my best to seek to connect them with stable housing because I know their names and stories. I know they're deserving of care and services and dignity. This is our calling. It's how we live out our beliefs and our missions. And to hold groups like us liable if something happens in the future is cruel and will hinder our ability to express our religious freedom and the care we show to the stranger, the foreigner, and all God's children.
Oh, thank you. Sorry. Do you want to go ahead and finish? You're almost finished.
Last
Turn your
sentence.
mic back on, please.
Thank you. In closing, this bill does nothing to address the broader challenges of our immigration status struggles in the United States. It only threatens to punish helpers and opens our state up to lawsuits around religious freedom. Thank you.
Very good. Thank you. Members, we have a list. First on the list, I have Representative Powell. I think you're recognized.
Thank you, Mr. Speaker, Mr. Chairman. Questions. A lot of times it's not just individuals. I mean, it also includes families and children. Is that correct? Can you speak to that?
Yes, that's what we see very much. The fastest growing demographic of people experiencing homelessness in the United States is families with children, it's youth, and it's seniors. So we're talking about incredibly vulnerable populations and people who did nothing wrong who are being affected by this.
President Powell, any follow-up?
Yes. And one last question. I know there's a lot of like federal laws that deal with housing. With this, do you feel like you run afoul of some of those different federal regulations that you have to follow when it comes to housing?
When it comes to federal laws, one of the things that's important is that we are a privately funded group, so we don't have some certain head restrictions. But I'll also say that the freedom of religion is something that we stand on as ministers and something that I'm incredibly concerned about this bill kind of butting up against.
Thank you.
Very good. Next on the list, I have Representative Bolso. Sir, you recognized.
Thank you, Mr. Chairman, and thank you, Ms. Cranks, for being here today.
Yes.
I want to ask you a few questions, and I hope put your mind at ease about whether this bill has anything to do with religious freedom. First, has your organization been in existence since prior to 2022?
We were founded in 2010.
Okay. And do you have an understanding that the statute that this bill seeks to amend, 29-34-213, did not even exist until 2022?
This bill is not something that I have like extensive knowledge of when it comes to its history. What I'm concerned with is the present bill that I have in front of me that we have concerns about.
Sure, but sometimes in order to understand an amendment to a law, it's necessary to understand what the initial law actually says. And here, prior to 2022, did you understand that your 501c3 organization could be held liable if it were negligent or grossly negligent and somehow that negligence harmed someone?
The first time that I've heard about this is now. And so what I'm concerned about is the ability that this brings to impact our ability to care for folks, which is our mission and our faith.
All right. Well, let me just state that prior to 2022, when the statute came onto the books, both your organization and every other nonprofit organization could be held liable for negligence or gross negligence or willful or wanton conduct if somehow it harms someone. And negligence has a very specific meaning under our law. It first requires that there be a duty of care which is breached. Then that breach proximately causes harm to a third person. And prior to this statute, your organization, as with all organizations, could be held responsible for causing harm, whether it related to someone who is an illegal immigrant or a citizen of the United States. And in 2022, this body passed this statute giving groups like yours immunity from any liability in cases of negligence. Here, what this bill is doing is it is actually restoring to the pre-2022 state where groups like yours could be found liable for negligence if it breaches a duty of care to someone who's in the country illegally. Do you understand that to be the case?
I hear what you're saying, yes.
Okay. And so the bill really has nothing to do with religious freedom because prior to 2022, yours and every other religious group in the state could be held responsible in court if it had a duty to a person, it breached that duty, and it caused harm. As the statute currently reads, a group like yours can only be held liable for gross negligence or willful and wanton misconduct. And all this bill does is it restores negligence to the category of harms for which your group and others could be held liable. And you have an understanding that your group provides services to both illegal immigrants and those who are citizens, regardless of their status, correct?
I think our concern is that the negligence in this bill isn't a gross negligence. It just says negligence. And so I think that feels kind of vague to me. So if we provided care for someone, helped them sign a lease to move into a private unit from a landlord that wanted to rent with them, that was working with them, and then something happened years down the road that was outside of our control. Negligence feels very broad and very vague. So I'm concerned that, like, did we know that they had a previous misdemeanor? Would that be used to show negligence on our part before we moved them in? Would that be? So I think that's my concern. I totally hear what you're saying. I appreciate you going through the history of the bill. I respect that and definitely try to do my homework on this too. But I think our concern coming to you today is that we're concerned about the definition of negligence being broad enough to potentially impact us in a way that we're just trying to connect people with housing. We're trying to live out our faith and our missions.
Is it true, Ms. Cranks, that your group had no difficulty from 2010 to 2022 with any negligence claims?
We've never had a negligence claim.
And if in fact this bill passes, and if it just returns the state of the law to what it was prior to 2022, you wouldn't expect that you're all of a sudden going to have negligence claims filed against your group, would you?
I think we're living in a different political environment than we were in 2010.
Well, whether the political environment is different or not, the legal environment is going to be the same after this bill is passed, if it's passed, as it was from 2010 to 2022. And given that all this bill does is puts us back to where we were in 2022, does that ease some of your concerns about this issue of religious freedom?
I wish I could say it eased my concerns, but I do think we're dealing with a different legal and political environment than we were. And we're going to do everything in our care to never show negligence. We're concerned about, I'm bringing the concerns of a body across the state, not just my own organization.
Great.
And those concerns persist, but thank you.
Thank you, Ms. Cranch. Thank you, Mr. Chairman.
Thank you. Representative Hardaway.
Thank you, Chairman. And ma'am, you'll be happy to know I'm just a layman. I ain't got no lawyer questions for you. You handled yourself well. I guess you're really in the position, and just to be clear, you're not a lawyer, are you?
I'm not an attorney, no.
And you're a minister, aren't you?
I am a minister.
So you're not here to do legal work, you're here to do God's work. And you want us to get out of your way, stay out of your way, so you can do that work. Is that right?
We are living out our faith and our calling every day.
Okay. So your concern, if I'm hearing you accurately, is that you were doing fine before this bill. And I think my colleague stated that before this bill that you would not have the degree of liability that you will have under this bill. He also asked if you'd had any incidents of gross negligence or negligence. He may have said just negligence. And you said no. So the question is, can you think of why this bill would have been proposed?
It's not clear to me if this body took this bill or made the amendment. It's not clear to me why this would be coming other than to punish people who help folks who don't have documents. And that's a concern that we have as people who see all people in this world as children of God.
All right. And when you look at the applications and interviews that you've done in the past, they've been sufficient to keep you out of trouble and keep you out of court.
Absolutely.
Yeah. So with this additional level of scrutiny that will come with this being put in statute, do you fear harassment, unnecessary accusations, and perhaps legal action where you will have to prove what you did not do?
It's not only us, but it's domestic violence groups and sexual assault groups across the state. I talked with the Tennessee Catholic Conference the other day who's been working on this bill. There's a number of groups with us that are service providers, that are faith leaders, that are concerned about this. So it's not something that I'm standing here because I have the freedom to do so, but a number of other groups have the same concerns that you mentioned.
And you don't have, if I heard you correctly earlier, you don't have government money flowing in.
Correct.
You funding yourself.
Yes.
So we don't have any type of funding that we can claim you have to do what we say. Or we're
Correct.
going to snatch your funding. You're doing this on your own. You're doing God's work. You're doing it out of your own pocket. And you just want us to stay out of the way so you can continue to do what you've been doing.
Correct.
All right. Thank you. Thank you, Chairman.
Thank you, Representative Hardaway. Next up, Representative Salinas.
Hi. Thank you, Chairman. Thank you, Reverend, for being with us today. Mike, I think you've answered some of my questions, but is it against your faith to ask someone whether they have documentation or not?
It's not. We often have to ask that to understand what people qualify for and what they don't qualify for.
And does the answer change the work that you're doing?
It changes what people can access.
Okay. Thank you.
We're good. Next up, Representative Travis, you recognize.
Thank you, Mr. Chairman. Make a motion, we go back in session.
Okay, that's proper motion, properly seconded. There is objection, members, so we'll be on the board for previous question. Oh, excuse me. We'll be on the board for go back into session. I apologize. All those in favor of going back into session, vote yes. Those opposed to going back into session, vote no. Very good, Madam Clerk. You just take the vote. Thank you.
Mr. Chair, you have 14 ayes, 6 noes, and 0 present not voting.
Very good. Motion prevails. We're going to be back into session. Thank you for being here. Representative Johnson, you're recognized.
Thank you, Mr. Chairman. I really had a question I can only ask the witness, but I guess I'll ask my other questions to the sponsor. One of the things that the witness brought up was probably the biggest concern that I had, and there's a lot of these groups, when you're trying to help homeless folks, you are not going for just overnight, you're going for permanent housing. So, you indicated that a lot of these organizations wouldn't be affected because they were just doing temporary housing. But a lot of these organizations do help to get people that permanent housing because that's really what people need when they are houseless. So, in the case like she described, where they do help people with permanent housing and signing a lease, then they would fall under this bill. Is that correct?
Chairman Grills.
Thank you, Mr. Chairman. And yes, they would.
Okay. And my follow-up to that is, we all know that she was talking about her Christian faith. We know that Christ taught welcoming the stranger. And so it is a Christian belief that we try to help people regardless of their status. And that's what these pastors and people of faith are doing. And so just a week ago, we were passing legislation that due to their religious freedom, folks were able to refuse to call people the names students, children, the names they wanted to be called due to their religious freedom. So why doesn't religious freedom apply here when they are just practicing their faith, which calls them to welcome the stranger?
Chairman Grills.
Thank you, Mr. Chairman. And what we are doing here, if someone is in the country illegally, they cannot be helped with long-term housing. That's what we're dealing with. If they are, you should bear the responsibility of if that person commits a crime. That NGO should bear the responsibility. If they've helped that person circumvent the law, then they should be held responsible for any crimes that person has committed against their fellow man.
I understand your frustration with the immigration system. I have frustration with the immigration system as well. We can't fix it at the state level. It needs to be fixed at the federal level. So why don't we put the pressure there, fix our immigration system so that people can come here, earn their way to citizenship, create a path so people can come, instead of going after the children and the families that are here. It just doesn't make sense to me. We have frustration with the system, but this is not a solution.
Chairman Grills, any response?
No, sir.
Very good. Representative Harris, you recognize.
Thank you, Mr. Chair and sponsor. So I'm reading under this bill, as long as a charitable organization does not ask or verify that a person's immigration status is legal, they can't be held liable for knowingly being aware that someone's.
Chairman Grills.
Thank you, Mr. Chairman. And Section 1C1, notwithstanding subsection B, a charitable organization that provides housing to a person whom the charitable organization knows is unlawfully present in the United States may be held. That's the language.
Thank you, Mr. Speaker. So I'm sorry, not much.
Oh, you recognize.
Thank you, Chairman. And so
I'll answer anything.
If that is the case, then how will that charitable organization know? Is there a requirement that they take some type of documentation or ask? But how are they knowingly aware?
If the charitable organization knows that these people are in the country illegally, and I'm assuming I do not operate a charitable organization that deals in this manner, but I would assume that they would have to know who they're dealing with. But if they do not know who they're dealing with, they're not going to give them long-term housing. They're not going to sign leases. They're not going to help them get a lease. They have to know who they're dealing with.
President Harris, any follow-up, sir?
Yes. And so aside from that, why is the bill singling out charitable organizations and excluding landlords and business owners from that own properties?
Are you offering an amendment?
No, I'm asking why. Yeah,
because we're just dealing with this section of code, and Senator Taylor brought this to me, and we worked on other important legislation, and I thought this was a good piece of legislation, so I filed it for him in the House.
That makes sense.
Very good. Thank you, sir. Next on the list, I have Representative Hardaway, sir, and then Bosa.
Thank you, Chairman. And morning to you, sir. I'm still confused. I know you said that Senator Taylor brought you this. Did you ask him what put this on his mind? Why he felt the need for us to go after these nonprofits, especially the church-related nonprofits who are doing what Jesus would do?
That's a conversation you need to have with Senator Taylor on what was on his mind. He brought the bill to me, and I thought it was a good piece of legislation, so I filed it thinking that it's a good idea to protect our citizens from people who are in this country illegally.
Okay, and I certainly agree with you. I'm as big a patriot as you are, and we're friends.
Absolutely.
And you're my ball caucus chairman. Okay.
That's right.
At the end of the day, I'd like to know that these organizations can do their work without interference from the state. Part of what I need to know is what level of care do they need to do in order to vet these folks? Is that going to change? Is what they've been doing acceptable? The minister that testified said it's been working for them. They haven't had any problems. So will we assume that whatever level of care they've taken in vetting these applicants for housing, that it won't increase the level of care?
If someone is in the country illegally and this charitable organization knows that they're unlawfully in this country and they help them circumvent the law and work with them to get a long-term lease, then they should be held liable.
Okay, so they're not compelled to ask them, are you a citizen?
That's not in this legislation.
Okay.
Representative Hardaway.
All right, very good. All right, thank you, sir. I've enjoyed our conversation.
As always, thank you.
Thank you. Representative Bolso, you recognize, Mr. Chairman, excuse me, Chairman Bolso.
Thank you, Mr. Chairman. I simply want to make 2 points. First, there was a question earlier about why this bill is targeted to charitable organizations and not to others. And I'll point out that the reason is simply that it was only to charitable organizations that this body gave immunity against negligence actions in 29-34-213. That just occurred back in 2022. So other organizations that are beyond the scope of the statute also already have liability potentially for negligent conduct. So although for-profit organizations are not covered by this bill, they are covered in the law. And then secondly, I believe some of the questioning demonstrates a bit of confusion about what the bill actually does. There are 2 different concepts at play here. One involves a concept called vicarious liability. If you have a charitable organization that provides housing to someone who's in the country illegally, and that person who's in the country illegally commits a crime, under this bill, the charitable organization is not automatically liable for any damage or harm caused by the crime. That is a concept called vicarious liability, which is not in this bill. On the other hand, if somehow the charitable organization breached a duty of care that it had to someone who brought a case, then in that event, the charitable organization could be found liable under this bill. But this bill does not impose liability on charitable organizations for the conduct of an illegal immigrant. Rather, it only imposes liability or restores liability for negligence to a charitable organization that engages in a breach of duty that approximately causes harm to a third person. And that, Mr. Chairman, are my 2 comments.
Very good. Thank you. Chair Grills, any response there?
I appreciate your support there, Chairman Bolso.
Yeah, thank you for the explanation, sir. And I have next on, let's have Leader Lambert. You recognize.
Move previous question.
Very good, members. Previous question has been called. There is objection, so we'll be on the board. Members, all those in favor of previous question, vote aye. Opposed, vote no. Has everybody voted? Anybody like to change their vote? Madam Clerk, if you would take the vote, please.
Mr. Chair, you have 14 ayes, 6 noes, and 0 present not voting.
Very good. House Bill, previous question prevails. Members, and we would be voting to send House Bill, 811. I'm sorry, I lost my place there. Members, we'll be voting to send House Bill 811 as amended to calendar and rules. All those in favor, vote aye. Opposed, vote no. Has everyone voted? Any member wish to change their vote? All right, Madam Clerk, if you'd please take the vote.
Mr. Chair, you have 15 ayes, 6 noes, and 0 present not voting.
Very good. House Bill 811 as amended is moving to calendar and rules.
Thank you.
All right, members, that brings us to item 22, Representative Parkinson. That's House Bill 1131.
Mr. Chair, I thought we were going to hear that one last. Did we change? If that's okay.
Excuse me, Leader Lambert, you recognize.
Mr. Chair, move to the heel of today's calendar.
That's proper motion, proper second. Any objection? Seeing none. House Bill 1131 is moved to the Hill. That brings us now to item, if we could move to item 49. That's House Bill 1050 by Representative Parkinson.
Thank you, Democrats.
Very good. Now, Representative Parkinson, I'm looking at, are you need to adopt two amendments or just one?
I'm not sure if the original amendment is traveling with the bill or not.
It's not.
It's
So
not.
we'll
So
probably
yes,
need to
sir, it'll be
adopt them
two.
both. Members, if we could, House Amendment 6153 is one of the two traveling with. They do? Okay. All right. I've been told that they both reroute the bill. So let's members, if we could back up and let's consider House Amendment 7115 since it's the latter file that's been filed. So that should suffice.
Yes, sir.
So if I can get a motion in a second on House Amendment 7115, you got a motion in a second. Members will go ahead and adopt that House Amendment to House Bill 1050. Any objection? Seeing none. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended and you're properly recognized.
Thank you, Mr. Chair, and thank you, committee. House Bill 1050 streamlines and strengthens rather Tennessee's nuisance laws to hold irresponsible business owners accountable when their establishments become hubs for repeated criminal activity. This bill establishes a clear legal threshold for when a business is officially designated a nuisance due to ongoing criminal activity. It provides a structured enforcement process to stop businesses from enabling crime, allows businesses and homeowners affected by the nuisance business to seek financial compensation, and it reduces the strain on law enforcement and lowers taxpayer costs by addressing chronic crime locations. And Mr. Chair, I think we have, well, let me say this first before we do that. This bill was worked on and the language was, we worked together on this with myself and the DA's conference. And I think we have members of the DA's conference that would like to speak on the bill. And we have a citizen who has been affected by one of these businesses. So if it's okay with the chair and the committee, if we can go out of session to hear from them.
All right, what I have who I have that's signed up on the list is I have Mike Donovan and I have Cynthia Smalls.
Yes.
Okay, members, any objection going out of session here from both of those two? All right, seeing none. We're out of session. Mr. Donovan, Smalls. If you two would just kindly come up here and have a seat there. Any seat at work? Yes, just fine. All right, you'll have 2 minutes apiece. So,
Yes,
ma'am,
sir.
we'll start with you and your mic's on. So just please introduce yourself and you have 2 minutes. Thank you.
Thank you, Mr. Chairman and committee, for allowing me to speak today. My name is Cynthia Smalls. My husband and I own Elite Child Care Center. We're located on Yale Road in Memphis, Tennessee. We have been a staple in this community for 6 years. We have seen the area go down from crime that stems from that establishment next to our daycare center. Recently, you all have seen there has been shootings active in the morning while children are at our location. There was drugs planted on our playground. The fence was kicked in. I have surveillance of them actually planting the drugs to distribute over in that area. I have talked to the property manager of that area over there with no avail. Nothing has happened. I have been working with Representative Parkinson for the trash that's been dumped. All of the gang activity. They do gang initiations behind the building. The shooting that recently happened caused my business to lose 9 children. We're only licensed for 42. So 9 children, and I had to let go of 2 employees. So they were affected. Also, the neighborhoods that have been plagued by such issues often see a decline in property values and businesses leave. I've been asked a lot of times, why don't you just leave? And that's not the answer. The answer is just fixing what needs to be fixed and holding them accountable for the things that they allowed to happen in front of their businesses. We've had shootings, we've had murders, we've had robberies, and this is all during the time that my children are in session. So ultimately, I feel like I am going to be held liable. I'm in the process of getting bulletproof windows put into my establishment just to make sure that my children are safe. I'm getting an indoor playground put in just to make sure that they can play because I'm not comfortable with them going outside. So I feel like this bill is a need for our community, not just for my business, but just for the surrounding area, because we have other businesses coming in, and with nuisances like this, they're not going to stay very long, and they're not going to thrive as well. So Parkinson has been a very, very help with getting some things done over there, especially with the trash pickup, buildup, and pollution, and not pollution, tires and all that good stuff. But we really need that business to be held accountable. Thank you.
Yeah, thank you, ma'am. Mr. Dummett, sir, as soon as your mic comes on, there you are.
Mike Donovan, Deputy Executive Director, Tennessee District Attorneys General Conference. Want to make it clear that this did not begin or start as a DA conference bill, but we were pleased and glad to help Representative Parkinson when he called upon us for some suggestions and some language in this bill. As you know, under current Tennessee law, the Tennessee Attorney General, any elected district attorney general, the county attorney, or the city attorney may petition a court, a chancery, or circuit court in the jurisdiction to abate a nuisance, a public nuisance. And the statute that currently exists lists several grounds and basis for that. What I understood Representative Parkinson's idea was to, as he said, streamline that process and make it more effective when there have been multiple events that occur at a certain property that demonstrates an ongoing nuisance. And so what you'll see from the bill, and we took some of this language from a current code in Georgia. Actually, Georgia code already does this. It establishes a prima facie evidence of a nuisance per se once there's a certain threshold of events or arrests for certain offenses at a location, at a proper location, and when the property owner has been given proper notice of that. And so you'll see that we have designed and designated those as sexually related charges, drug-related charges, assaultive charges, firearms-related charges, and property or juvenile-related charges. Again, once there is a threshold of 3 arrests for any one of those combination of offenses at a particular location, and the property owner is put on notice, once there is yet a 4th event that occurs, that establishes a per se nuisance that makes it easier to abate the nuisance in a court of law. Thank you.
And thank you. Members, any questions? I have Representative Powell. He's first on the list. Hardaway.
Thank you. I'm actually very familiar with beta nuisance, dealing with some of these issues in the community. A question, when these are pursued, if someone is a property owner, but there's a business operating there, is the business liable, or is it just the property owner that is pursued upon?
Mr. Dummett.
Typically, when district attorneys initiate these petitions, notice is given not only to the property owner, but the property occupier. Typically, and a lot of times, the owner is absent, and the occupier is a lessee or someone who's occupying the property as a rentor who may actually be maintaining the nuisance themselves. And that could be an ongoing business, or it could be an apartment house or something like that. And so we always serve notice on both the owner and the occupier.
President Powell.
And then a follow-up. So if this is pursued, then under this law, would the property owner and the business entity both be held accountable under this, or?
Mr. Donovan?
Yes. The answer is yes. They would both be served with the petition to abate the nuisance, and they would be required to come into court and defend that action and explain to the judge why either a nuisance does not exist, or that they're taking measures to stop or cease that activity at that location.
Any follow-up?
Just one other follow-up. And I realize, so if the property owner had a lease in place, and typically, hopefully the lease would address these concerns, but you'd be surprised. I've seen some pretty unusual leases in my time. Is there any sort of liability that you've ever encountered where the business could try to serve liability on the property owner, even though the property owner, was trying to solve the problem, but the business, if they had to cancel the lease, there might be some sort of liability on the property owner?
Mr. Dummett?
I'm not aware of the relative liabilities between a lessor and a property owner. What I will tell you is that the government official, whether it's a district attorney, a county attorney, or the attorney general who serves those petitions for abatement of a nuisance, we serve them on both. And then typically that results in a temporary restraining order and a shuttering of that property. That is a padlock, shutting that place down as a temporary matter. And then those property owners or occupiers have to come into court and demonstrate either that the nuisance did not exist to begin with or that it's been abated or dealt with. What this proposed language does is sets up essentially a prima facie evidence of a nuisance per se after a certain number of those events have occurred and notice has been given of those arrests for those offenses to the property owner or occupier.
And last question, under this bill, do the events have to be 3 separate occurrences, or if something happened, could you have 3 simultaneous actions all at once and that would kick this in effect, or does it have to be 3 separate different occurrences?
Mr. Dunnett.
The way that we attempted to craft the language in this bill indicates that any combination of any of these offenses in 3 or more unrelated incidents, and unrelated means what you think it means. It means they would not necessarily be simultaneously occurring.
All right. Next on the list, I have Representative Hardaway.
Thank you, Chairman, and greetings to you, sir. Good morning to you. Just a couple of technical questions. Is this bill, is it about the zip code or the distance from the site of the nuisance?
You guys go and have an exchange. You don't need to be recognized every time.
No, sir. The way that I understand the amended bill as it reads does not limit this to zip code or to area. It's really any property where there is this nuisance per se that's been established by the repeated unrelated events of arrest for those listed offenses. So I don't think that's relegated to a particular zip code. Now, I do understand that perhaps there was an additional amendment that added a private action, a right of action for a citizen, and that might be applicable to a zip code, but I was not involved in the drafting of that.
Okay, I'll wait until we get back in then. And if there's the awardance, if you're awarded the $50,000, 1,000 up to $50,000, will that preclude any additional civil suits?
Again, Representative Hardaway, that part of the amendment I did not have input on. That might be a question for legal. I primarily worked with Representative Parkinson on the language regarding the nuisance per se and the different nature of the offenses that might be included for arrest to establish that nuisance. So I'm sorry, I don't know the answer to that question.
All right, and this is my last one, Chairman. Currently on the third nuisance, if you had 2 earlier convictions or findings, what would you be doing now without this bill?
Well, under current law, what the law really requires the district attorney to show is a pattern of repeated nuisance behavior, and there's no really time frame that's set in current law. This sets a time frame of that 24 months, and sometimes those patterns are hard to determine or to prove. This sets up something that basically automatically triggers that after notice of the third arrest. That is not calls for service, it's an arrest. So we have an actual documented arrest of someone who is committing these criminal offenses on or near that property that's constituting the nuisance itself. And then after notice to the property owner, if that's not abated and you have a fourth in that period of time, it triggers the ability to file a petition, and the court essentially can take that as a nuisance per se. So we don't have to establish that pattern.
So the pattern would involve arrests, not convictions?
That's correct. That's the way that I drafted it. Yes, sir.
Okay. All right. Thank you, sir.
Very good. Leader Lambert, you recognize.
Move to return to session.
Very good. Members, any objection? Seeing none. Thank you both for being here. Back in session. We're back on the bill, members. Representative Parkinson, any follow-up? Representative Travis, you're first on the list.
Thank you, Mr. Chairman. Call previous question.
Very good. Previous question has been called. Any objection to the question? All right. Seeing none. Members, we're going to be voting to send House Bill 1050 as amended to calendar and rules. All those in favor, vote aye. Opposed, vote no. Has every member voted? Any member like to change the vote? All right, Madam Clerk, if you would take the vote, please.
Mr. Chair, you have 17 ayes, 1 no, and 2 present not voting.
Very good. House Bill 1050 will be moving to calendar and rules. Thank you. As amended. And what we're going to do, we're going to move back to, we're going to move back on to item 46, Representative Fritz, without objection. Oh. So you got a motion and a second. That's House Bill 873. And members, we have House Amendment 4178 traveling with us. Got a motion and a second. Members, we will go ahead and adopt this amendment. Any objection to adopting House Amendment 4178, House Bill 873? Seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized.
Thank you, Mr. Chairman and committee. Bill 873 is legislation that makes additions to law that the General Assembly passed in 2023 that extended protections of the Federal Protection of Lawful Commerce and Arms Acts to the state level. These additions protect firearms manufacturers from foreign claims of civil liability, foreign meaning other states or other countries. State courts would be blocked from recognizing foreign judgment. It also expands the list of manufacturers to which this legislation would apply. As most of y'all are likely aware, the nation of Mexico has currently filed suit against Smith & Wesson and other domestic manufacturers. They're blaming them for the violence they have in Mexico, which I find ironic. But our manufacturing jobs are at risk to these vicious type lawsuits. According to the Tennessee Department of Economic Development, in September of 2021, Tennessee became the #1 per capita in the nation for employment in the firearms and ammunition industry with nearly 8,000 jobs. It's estimated that this industry contributes $1.1 billion to our economy each year. There are 20 firearms and ammunition manufacturers in the state, including big investments by Smith & Wesson in Blount County. And Beretta has just announced, Beretta has manufacturing facilities in the state, and we have another investment coming from Barrett Farms of $75 to $80 million. Reducing the amount of risk on these Tennessee businesses will give us an advantage in seeking to recruit additional industry. And this is indeed a Second Amendment issue. So with that, Mr. Chairman, I'd pause and take any questions, ask for your favorable consideration.
Very good, members. Any questions for Representative Fritz? Representative Johnson, you're first on the list.
So, thank you. And to the sponsored, so this includes, in addition to firearms, it also includes pepper spray, silencers, that other list. Is there anything in there that's pretty common that's not written down? I'm just curious what else that might entail. It's because it says other certain products.
Representative Fritz, you're recognized. You all can have an exchange. You don't have to be
Mr. Chairman.
recognized every
Thank you
time.
for the question. I'm not sure what the definition of pretty common would be, Representative, if you give me an idea of what you're referring to. I'm not trying to elude your question. I just want to make sure I answer.
Common means people are aware of it. So just other things that folks, constituents of mine might have or carry that this would also affect.
Again, I'm struggling a little bit with the question. This bill simply protects the manufacturers. It does expand the coverage to mace, as you mentioned, and some things like that.
Right.
Because one of the things that we're seeing, there's an old Sun Tzu or George Patton quote that says that any fixed position is ultimately not defensible. And so with these aggressive anti-gun tactics to try to shut down our Second Amendment rights and also to shut down the businesses, as they did with Remington a few years ago, to produce those firearms and manufacturers, some of these attacks have gone at some of the supplemental sales in the retail stores. And so this bill protects those as well.
I just struggle to be okay with allowing corporations to be immune from the citizens being able to get justice for a bad product. It's, different about like how you access the product. That's certainly not the fault of the company, but being able to bring a question based on a product, especially when we're talking about chemicals and however they're administered, whatever format that you're carrying them in. I think that the people should have the ability to have justice in those situations.
Any follow? Very good. Members, I have next on the list. Have Chairman Todd, you recognize?
Thank you, Mr. Chairman. And I just want to thank the sponsor for allowing me to co-sponsor this bill. Thank you for bringing it.
Very good. And that's all we have. Members, are we ready to vote? Any objections to the question? Looks like we're seeing none. Looks like we're ready to vote. Send House Bill 873 as amended to calendar and rules. All those in favor vote yes. Those opposed vote no. Has everyone voted? Anybody like to change the vote? All right, Madam Clerk, if you would please take the vote.
Mr. Chair, you have 17 ayes, 5 noes, and 0 present not voting.
Very good. House Bill 873 as amended is moving to calendar and rules.
Thank you, Chairman, Committee.
All right, members, folks, if we could just move back to the top of today's calendar, or near the top there. If we could move to item 23, House Bill 322. Chairman Todd, I know I may have caught you off guard there, but we can get to where we need to be. You have the motion in a second there. We have House Amendment 6449, sir.
That's
You've got
correct.
a motion in a second. Members, any objection to adopting House Amendment 6449 to House Bill 322? All right, seeing none. All those in favor vote aye.
Aye.
Or say aye. Aye. Opposed, say no. Ayes have it. All right, Chairman Todd, we're back on your bill as amended, and you're probably recognized.
Thank you, Mr. Chairman. And this bill does a few things. First, it creates a crime of human smuggling because smuggling involves different forms of activity than many trafficking violations, namely crossing international borders and transport of larger number of victims. And a lot of times those victims may not even realize they're victims at that point. They're being smuggled for the purpose of human trafficking, yet they think they're just being transported, and law enforcement can't do anything until a crime is committed. So they have to then become victims of trafficking in order for the perpetrators to face any punishment. It also gives law enforcement and the Attorney General the effective tools for prosecuting human traffickers and human smugglers, and it's focused on the methods and techniques that are in use, namely forced labor and forced sex slavery, all for commercial advantage and financial gain. This goes after human traffickers who force mostly minor females into involuntary labor servitude, forced labor, trafficking for commercial sex acts, prostitution, and human smuggling. The last section of the bill also creates a crime of harboring or hiding individuals within this state that are here in this country illegally. So with that, I'll be glad to take any questions.
Members, any questions for Chairman Todd? Representative Johnson, you recognized.
Yes, in the question that I have, that some constituents have, is in the last section. It says that it doesn't apply to a legally licensed lawyer or a licensed attorney. But the question and the situation that was presented to me was, what about an employee? It could be a government employee, it could be a paralegal, that it's part of their job to advise on where you can get assistance. And so the lawyer is actually protected, but someone else who might be put in that position of having to advise as their job wouldn't be protected under this bill as an attorney would.
Chairman Todd.
So if the persons you are referring to are harboring, meaning housing, or hiding, or assisting another in harboring or hiding, those individuals that are here illegally, then that would be a crime if they don't fall under the category of being an attorney or a health services provider as stated in the bill.
Yes, and I understand that, but the attorney is his liability or her liability is taken away. But these people are acting in the same way that the attorney would. They're just not licensed as an attorney, but they're doing it on their behalf. So if they're giving the same advice, they're advising, it seems like they should have the same protections that the attorney does because they are literally doing their job as required.
Advising is not a crime. It is literally harboring, which by definition means housing or hiding, and then specifically or hiding here. So harboring or hiding is the problem. That is the crime, not assisting someone like feeding them or pointing them in the right direction or some other type of assistance.
Could we verify that assisting or giving advice is not a crime under this bill with legal?
Members, any objection to going out of session here from Ms. Fogarty? All right, seeing none. Ms. Fogarty?
Michelle Fogarty, Office of Legal Services. Under the amendment being considered, it is an offense for a person to harbor or hide or to assist another in harboring or hiding within this state an individual whom the person knows or should have known has illegally entered or remained in the United States.
Okay, thank you. And that's why you had to excuse lawyers, because it is in assisting is also part of the bill. Thank you.
Representative Salinas, did you have a question for legal?
Yeah, I understand that lawyers would be immune from the assistant portion of it. Immigration lawyers deal with federal law. So would this law apply only to Tennessee barred lawyers or lawyers from anywhere in the United States that work on federal immigration laws?
Under the language as written, it's an attorney who is licensed and admitted to the practice of law in this state.
So a immigration lawyer from that takes cases in Tennessee that is not, let's say, I mean, I'm from Memphis. Mississippi, Arkansas are our border states. We have immigration lawyers that are barred in those states that practice in Memphis. They would not be protected by this.
Not
clause.
if they are not licensed and admitted in this to practice law in this state, they would not be covered by the language in the amendment.
Okay, thank you.
Representative Powell, you're recognized.
Question for legal. Under this bill, if somebody resided, maybe even was married to someone that was in the country illegally, and resided with them, could they be considered harboring that person?
That would be a factual determination for the trier of fact to make. Certainly.
So just to be clear, if someone was married, they've been married to this person legally for years, that unfortunately they would be considered a criminal under this bill and be guilty of harboring potentially based on the facts.
That is a possibility.
Thank you.
Good. Any additional questions for legal? Legal, okay. Representative Hardaway, then Towns.
All right. Thank you, Chairman. To legal counsel, on the area of the bill that deals with providing health care services, would that require you to be a licensed or registered healthcare provider?
Under the language in the amendment, there is an exclusion for a person who provides healthcare services or assistance to an individual who presents at a healthcare facility that is licensed under Title 68 or Title 33, or the office or other practice site of a healthcare provider licensed, registered, certified, or otherwise permitted to deliver healthcare services under Title 63 or 68. So the person themselves would not necessarily have to be licensed, but they would have to be providing services or assistance at a licensed facility or at the practice site or office of a healthcare provider who is licensed.
So if the healthcare provider was to lend healthcare assistance at a church that did not have a clinic, then that healthcare provider would be in violation of the statute, this legislation rather, as proposed.
I can tell you that the amendment says that a person who provides healthcare services or assistance to an individual who presents at a healthcare facility that is licensed, or the office or other practice site of a healthcare provider who is licensed under Title 63 or 68 of the TCA, is not violating the statute, but it's persons who provide services or assistance to an individual who presents at either the facility or the office of a person that is licensed.
All right. Is there any other connection between this and the the bill that we heard earlier that Senator Taylor made, Representative Grills carry?
No, the bill that was previously considered by Representative Grills dealt with civil liability. This language creates a criminal offense.
And that's okay. I'll wait until we get back in, Mr. Chairman. Thank you, Council.
We're going to have Representative Towns, sir. Any questions for legal?
Sure. Thank you. Legal, under this bill, criminal offense, what is the penalty in the event someone is violating this proposed law? What are the penalties?
So the bill creates two separate criminal offenses. The first criminal offense would be the offense of human smuggling, and that offense is a Class E felony. It also creates the offense of aggravated human smuggling, which would be the offense of human smuggling when the victim is less than 13 years of age at any time during the person's course of conduct, and that is punished as a Class A felony. The offense that we were just discussing, the second separate offense of harboring or hiding, is a Class A misdemeanor, punishable only by a fine of $1,000 for each person that is harbored or hidden.
Okay, thank you. Now, there was a question asked earlier as it relates to a married couple. How does this impact whether or not a married couple could testify against each other? I thought there were laws in the books that prevented that.
There is a marital privilege that can be raised by a spouse.
So is that saying that they would be forced to testify or not?
Depending on the facts and circumstances of each case, I can't predict what type of evidence the district attorney would have to offer to prove the facts, the elements of the offense. Right. Yeah, and the privilege doesn't apply to criminal liability.
So you're pretty much saying that it cannot be a defense. Is that what we're saying?
Correct.
Representative Salinas.
Thank you, Chairman. The bill is very vague, and GA kind of brought some questions to my mind regarding the healthcare portion of it, so I wanted to go back to that. So it's only if it's at a licensed healthcare facility that there's an exception for, right?
The language states that it is not a violation of subsection A, which would be the offense of harboring or hiding or assisting another in harboring or hiding. It is not a violation for a person to provide healthcare services or assistance to an individual presenting at a healthcare facility that is licensed under Title 68 or Title 33, or to an individual presenting at the office or other practice site of a healthcare provider licensed, registered, certified, or otherwise permitted to deliver healthcare services under Title 63 or Title 68.
Okay. The reason why I ask is because we have in Memphis a lot of housing that is related to healthcare, but they're not registered. So I'm thinking of like the Ronald McDonald House, Target House, all of which are involved with pediatrics. So if a healthcare provider were to go provide healthcare for the kids that are staying there and very sick, they would still be liable under that section. Is that correct?
Again, the facts and circumstances of each case would be, I can't speculate. It does say, or other practice site of a healthcare provider who is licensed, registered, or certified under Title 63 or 68. It's just would be very fact dependent.
Okay, thank you. I really appreciate it because the bill is very vague in a lot of this stuff. And
All right, members, that's all we have. Any objection going back into session? Seeing none. All right, members, we also have we have two folks here on the list to testify to this bill. I have Ms. Warmington and Cohen. Ladies, if you want to come here and have a seat. And we'll start with Ms. Cohen, I believe. And once your mic's on, it'll be red there, and you'll have 2 minutes each. Just introduce yourself, and there you go.
Thank you. My name is Johanna Cohen. I'm a Republican from Robertson County. Thank you, Chairman, Committee, and Sponsor for allowing me to speak today. I'm opposed to this bill. I'd like to share with you my experience. When I was 10 years old, my dad got an opportunity he couldn't pass up. Unfortunately, the 2-year contract was 900 miles away from our home. Neither of my parents wanted to uproot us. My mom worked nights and needed someone to stay overnight. Our Catholic church reached out to her. A young woman undocumented from El Salvador was in need of a job. She stayed at our house during the week and stayed with her family during the weekend. Today, years later, she is a United States citizen, as are her 2 sons who got their citizenship through birthright and have both served this country, one in the Marines and one in the Army. She didn't come here and risk her life on a whim. She came here like generations of people have for safety in the future. If you trace your family back to beyond the 1880s, then they came when immigration was much different. They never had to know the struggle of our broken immigration system. The immigration process to gain citizenship is a long and expensive one. With this bill and other bills passed in these committee rooms, my parents and our Catholic Church would be charged with a crime. But I've also heard you talk about many bills in this committee room protecting one's deeply held moral and ethical beliefs. Well, I have a deeply held belief that is expressed in Corinthians 13, and now these 3 remain: faith, hope, and love. But the greatest of these is love. Matthew 25, whatever you do for the least of my people, you do for me. Hebrews 12, do not neglect to show hospitality to strangers, for thereby some have entertained angels unawares. And John 13, a new commandment I give to you, that you love one another just as I have loved you. You also are to love one another. By this, all people will know that you are my disciples. Where is the protection for my deeply held moral and ethical belief of love and charity, feeding the hungry, caring for the sick, recognizing the image of God in all people? If only this body spent half as much time protecting the deeply held moral and ethical beliefs of Christ that are meant to uplift people, instead of concern over the deeply held moral and ethical beliefs of some Christians that are meant to deride. So again, my name is Johanna Cohen from Robertson County, and if you pass this bill, I will disobey.
All right. Now, Ms. Worthington, ma'am, you're recognized.
Thank you. Good morning. My name is Ashley Warbington. I grew up in Tennessee and now I'm raising my family here. My husband, the father of my child, is undocumented. I'm here today to oppose this bill because this bill will hurt families like mine, as we just heard legal confirm. My husband and I live like any other family. Our son goes to a public school where the majority of the students are Latino. We attend his baseball games. We take him to the doctor. But under this bill, these everyday things could become crimes. This bill is so unclear and overreaching that it could turn basic acts of love and responsibility into felonies. For example, if I drive my husband to a medical appointment, would that be smuggling? If I refuse to open the door to immigration officers without a proper judicial warrant, would I be charged for harboring? What if my son's friend comes over to play and his parents are undocumented, or he is undocumented? Would letting them into my home make me a criminal? Should I start asking about someone's immigration status before I let them in my car or into my home? What about translating for someone? I speak both English and Spanish, and sometimes I help other parents at my son's school by explaining forms. Could that be considered encouraging or inducing someone under this bill? It's unclear, and that uncertainty makes this bill dangerous. The language of this bill is so broad that it opens the door to misuse and overreach. It puts people like me, community members who are simply trying to help others, at risk of being unfairly labeled as criminals. This bill doesn't just create confusion, it creates fear, discourages kindness, and erodes trust within our communities. Let's also compare this bill to a similar approach that Alabama is taking right now with SB 53. While I don't agree with what they're doing, at least they took steps to include protections for school staff, ensuring teachers and counselors wouldn't be punished for doing their jobs. Tennessee hasn't done that. HB 322 fails to consider the impact on educators, volunteers, and support staff, leaving them exposed to unnecessary legal risk. The truth is, this bill is unnecessary. There are already federal laws in place to deal with serious crimes like human trafficking and smuggling for profit. Immigration enforcement is unequivocally a federal responsibility, as courts have consistently ruled. States cannot create parallel laws that intrude upon federal immigration authority without violating the constitutional principle of federal preemption. Arizona spent around $3.4 million defending Senate Bill 1070. Are we going to make the same costly mistake?
All right, thank you. You're right at 2.5 minutes there. So members, any questions for our guests? All right, Representative Johnson, you're recognized.
Thank you. And you brought up a really important issue that someone else brought to my attention, and that is school staff. They would be acting as in their duties, and do you see them coming in violation of this law, the way it's written?
100%. I think the vagueness of the law, and I think, as we heard earlier, with just someone like myself living with my husband, that puts me at risk. That means that educators as well will be at risk. And Alabama saw that and they excluded it along with the lawyers. They have excluded both educators and lawyers from a similar bill that they have running through. I would like to add that other states have attempted to do this and they have all been blocked because of Arizona v. US.
Thank you. I mean, it's a really critical issue for educators and for staff at schools, not just the faculty, but staff as well. So thank you for bringing that to light. And it is incredibly dangerous. Thank you.
Good. Members, any additional questions for our guests? All right, seeing none. Thank you all for being here. Any objection going back into session? All right, seeing none. All right, members, we're back on the bill. Chairman Todd. Any questions for the sponsor?
Thank you, Mr. Chairman. I'll mention some things this bill does not do. You've heard several things here listed, and a lot of that is incorrect. This does not create a criminal liability to any individual or charitable organization that provides temporary shelter, food, or assistance to an individual who they do not know or have reason to know has entered or remains in the U.S. illegally. Does not create a criminal liability to any individual or charitable organization that provides an individual with transportation without any commercial advantage or private financial gain. And it does not create criminal liability to any individual or charitable organization that provides an individual with transportation without the intent to conceal that individual from law enforcement or federal immigration officials. It does not create a criminal liability to an individual or charitable organization that encourages or induces an individual to enter or stay in Tennessee illegally without concealing, harboring, or shielding that individual from detection by officials. Those are things it does not do. So I can reiterate what it does do as I went over first, if anybody wants that, but the bill is laid out very clearly, very simple language. I think it reads very easily for the public to know exactly what we're doing. So with that, I'll be glad to take any additional questions.
Members, any questions? Seeing none. Well, excuse me. We have the list. Okay, Garrett, Representative Garrett, you're first on the list. Thank you.
I move previous question.
All right, previous question has been called. Any objection? All right, members, I'm seeing an objection. We're on the board. All those in favor of previous questions, vote yes. Opposed, vote no. Does everyone vote? Anybody like to change the vote? All right. Madam Clerk, if you would please take the vote.
Mr. Chair, you have 16 ayes, 6 noes, and 0 present not voting.
Very good. Previous question prevails. Members, we're going to be voting to send House Bill 322 as amended to Finance, Ways, and Means. All those in favor vote yes. Opposed, vote no. Has every member voted? Any member would like to change their vote? All right, Madam Clerk, if you please take the vote.
Mr. Chair, you have 16 ayes, 6 noes, and 0 present not voting.
Very good. House Bill 322 as amended is moving to Finance, Ways, and Means. That brings us next to item 28, House Bill 729. Chairman Keesley, sir. Second. You've got a motion and a second, sir, and I see House Amendment 3830. Members, we've got a motion and a second on that amendment. Do we need to adopt that amendment? Chairman Keesley?
Yes, that's the one I need to get.
Very good. Members, any objection to adopting House Amendment 3830 to House Bill 729? Seeing none. All those in favor say yes. Yes. Opposed, say no. The ayes have it. All right, now we're back on the bill as amended.
All right, thank you, Chairman and members. This House Bill 729 is relative to the obstruction of a passageway. Now, currently, our law states that a person who knowingly obstructs a highway or a street, railway, waterway, elevator, aisle, or hallway commits a Class A misdemeanor. Now, with the adoption with the adoption that we just made with 3830, that does take the sidewalk, it eliminates the word or the term sidewalk. So simply put, this increases from a Class A misdemeanor to a Class D felony for the offense of obstructing a highway or other passageway if the defendant intentionally obstructs the highway, again, street or other place used for passage of vehicles. That, Mr. Chairman, with that, I will entertain any questions.
Thank you, sponsor. So we have some folks that are here to testify. We have Macy Fluharty, Will Connolly, Meredith McLeod. So members, do you mind going out of session so that we can hear from these individuals? Out of session. All right, so we'll, Macy Fluharty, if you're here, please come up. Will Connolly and Meredith McLeod. Just the two? Okay. You have 2 minutes. Please identify yourself and we'll start the clock. Just whoever wants to go first, just please identify yourself. Thank you.
My name is Macy Fluharty. I'm a Davidson County resident. This bill risks another jab at our right to assemble and protest. While the amendment removing sidewalks, hallways, etc. from offenses is appreciated, the original text of this bill is still rather telling. The Republican Party is on a manhunt against our right to free speech, assembly, and association. Over recent weeks, we've seen legal residents and citizens detained without due process, triggered by their exercise of our First Amendment rights. This bill, like others proposed by this legislature this session, comes off as a continued intimidation to silence constituents from protesting. If we want the protests to cease, your attacks on us, the people, and our earth must end first. Last year, I testified against an eerily similar bill to this, and we spoke about overflow during protest. Should an action become so popular it spills onto streets, police should be alerting the crowd of this bill and helping contain the people. This is not uncommon in protest and can sometimes be necessary more than once. When does a cop abandon their prescribed duty to public safety and decide to start slapping felony charges onto people exercising free speech, immediately escalating the situation? How does the state decide if this was intentional? How is it decided who's to be charged? Is it the protester that might have briefly stepped off a sidewalk? The organizers who are trying to keep people on track? Is it the whole crowd? This bill pins police between keeping public safety alongside legal and patriotic acts versus a demand to charge citizens with life-changing felonies. This bill further criminalizes the possible unintended results of exercising our constitutional rights. Changing charges to a high felony is ridiculous. These charges are used for things like murder, rape, etc. When someone is charged with the felony, they lose their rights, like the right to bear arms or vote. This bill seeks to put that same punishment onto people simply demonstrating our First Amendment rights. The punishment does not fit the action. To obstruct a passageway is already illegal. Changing this to a felony is absurd. Again, if we want the protests to cease, your attacks on us, the people, and our earth must end. It is shameful that our legislature...
Yeah. Ma'am, I'm sorry, you've gone over your 2 minutes. I'll let you go for another 30 seconds, but. Thank you. Yes, ma'am. Are you Ms. McLeod?
McLeod, yes.
McLeod, thank you.
Sorry, my phone just locked. Okay. Thank you for the opportunity to speak today. My name is Meredith McLeod-Jolin. I'm the executive director of a local nonprofit here in town. I'm also a licensed clinical social worker specializing in the trauma treatment, and I serve on the Homeless Planning Council, the Encampment Prioritization Team, and the Metro Swap Committee. First, I want to sincerely thank you for the amendment that you have made to this bill. Removing sidewalks makes a huge change and is deeply appreciated. This helps address some of the unintended consequences that we were initially concerned about. I truly believe everyone in this room wants these policies that build stronger, safer communities, and I'm grateful for the openness of your feedback. As you consider the final language of this bill, I'd like to ask you to take one more step to consider how this legislation could affect someone like me. I have no arrest record. I'm a mom, a social worker, and a nonprofit leader, and I've attended hundreds of peaceful protests to advocate for what I believe in. I've exercised my constitutional right to assemble because I care about my community. Under the current language, however, it is not hard to imagine how a peaceful demonstration could escalate into a situation where someone like me could suddenly be facing felony charges that could alter my ability to serve my community in the course of my life. That's not theoretical. That's a very real possibility when felony level penalties are attached to situations that might involve little more than being in the wrong place at the wrong time. We've already seen how laws like the felony camping statute, never intended to criminalize homeless individuals, have resulted in arrest. Between October and November of last year, 11 individuals in Nashville were arrested because of this bill. This bill, without additional safeguards, risks repeating that pattern. I appreciate the progress that has been made so far in the efforts to find the right balance. A small clarification around enforcement could go a long way in ensuring that well-meaning people, whether they're housed or simply exercising their right to protest, don't end up facing life-altering penalties for violent actions. Thank you for your time.
Thank you. Members, do we have any questions for the witnesses? Representative Johnson, you're recognized.
Thank you, Madam Chair. I guess one of the things when you were talking, what brought up to me was I participated in a march in Knoxville, and we were crossing the street, and I wasn't familiar with the organizers. So I believed in what folks were doing, but I didn't know the organizers personally. So I didn't know if they had a permit. I didn't know any of those things. So as we were crossing the street, they stopped in the street. I felt more comfortable. My comfort level was better on the sidewalk, but they stopped in the street, and I think it was 7 minutes that they were stopping, and there were officers there. And so as someone who was participating, I didn't know they had permission to stop. That was part of the plan. But I think the point that you made with people joining a march or joining a protest or something like that, they don't always know what the rules are. And they may think that there's a permit, or they may think, well, this is a planned action, we're allowed to do this, and they might participate. And I think you sort of expressed that when you talked about people joining in and that sort of thing. So that is my fear. People who just want to get involved in a community action may not have all of the details and end up with a felony. Do you all feel that this is something that is a legitimate concern with this bill?
I personally think so, especially since a lot of the organizing that is being done on social media. So it's really hard to vet how, is this just something that has gone through and is appropriately permitted and all these things, or is this something that somebody has just decided they're going to do? So I think we're putting people at risk just for their amendment to free speech.
Thank you. And do you have a concern with that?
I completely agree. And like the co-panelist said, there are going to be people that have no criminal past, any charges or anything on their record, that are just simply exercising their right to free speech and could get caught in the wrong place at the wrong time or anything like that, step off the sidewalk for just a minute to walk around a fire hydrant, and that can trigger a cop abandoning their right to public safety, to slap felony charges onto somebody, which could result into escalating the situation even further.
Thank you.
Representative Powell, you're recognized.
Thank you. Question is, we have a long, rich history of protests and marches. In fact, you think about the march in Selma, and actually the street in front of us that John Lewis participated in. I've got multiple concerns here, but as someone, I know you've actively, mentioned you protested.
Mm-hmm.
I mean, I've protested against government at times, and what government's doing. So don't you feel like that if people want to actively protest their government, and it's the government that then has to issue these permits to be in these places, couldn't we be in a situation where basically government is controlling our right to protest, what seems completely contradictory to our Constitution? Could you speak to that?
I mean, I think you were right on the money with that, is we are asking for permission to have a freedom of speech, something that we shouldn't have to ask for permission to have. We are not trying to cause issues. We're just trying to have our voices be heard in a nonviolent way, in the way that we were taught in school, that this is how you make changes in the government. And that is being told that we have to have a permit or we could face jail time.
Thank you.
Representative Bolso.
Thank you, Madam Chair. I move that we go back into session.
Any objections? We're back in session. Members, we do have some folks that were interested in speaking to the bill sponsor. Representative Johnson, you're recognized.
I guess, again, my question would be that same question of those folks that are participating and, are just, are, maybe not aware of what the plan is or what is everything that's taking place and are just going along with the march as it happens. And I think when the speaker said, step off the street to go around a fire hydrant. I think of how many times I've had to do that going down the sidewalk in a march and you've either gone around a light pole or you've gone around something on the street side. So I just think that this puts so many people at risk who are literally just exercising their right to free speech and the concern of getting a felony because of that. So I guess what I'm asking the sponsor is what guardrails are in this bill to prevent that?
There's no.
Chairman
Yeah,
Kiesling.
okay, thank you, Madam Chair. No, this is all about safety. This is all about the traveling public. This no one is trying to prevent anyone from marching. If you're going to march or you're going to do whatever you along those lines, then I think I certainly would want to know the rules of the road, the rules of the protest. So with that, I renew my motion, Madam Chair.
Representative Salinas, you're recognized.
I didn't realize I had my hand up. So this is already a crime. It's already a misdemeanor. Do you have any research or anything that says that making it a Class C felony will deter that? Because I think it's just going to clog up our system.
I'm sorry. Would you repeat that, please?
So blocking a highway is already a crime. So it's already a misdemeanor. Do you have any research on making it a Class E felony that would deter?
No, I have no research. No.
Okay.
Representative Scarborough, you're recognized.
Sponsor for the bill. I think it's, as he said, I want to echo his thoughts. It's a safety issue. Anytime we're putting pedestrians versus vehicles, it is a dangerous situation. Those roadways are meant for one purpose and one purpose only. And there's plenty of other opportunities for a protest to occur. But there needs to be a reasonable expectation for the public to be safe. And once we allow them in the roadway without these type of penalties, that doesn't give the opportunity for law enforcement and the public safety officials to provide a safe haven, if you will, for the protest. Again, I appreciate the sponsor's intent. And with that, I call previous question.
I'm sorry, that's not proper. So I appreciate that, though. Representative Kiesling, any response?
Renew my motion.
Thank you, sir. Representative Bolso, you're recognized.
Thank you, Madam Chair. I move previous question.
That's proper. Thank you. Any objection? All right. Members, we're going to be voting on previous question. All in favor, vote aye. Those opposed, vote no. Does any member want to change their vote? Madam Clerk? Oh. All right, Madam Clerk, record the vote, please.
Madam Chair, you have 14 ayes, 5 noes, and 0 present not voting.
Thank you. We will now be voting on House Bill 729 as amended. All those in favor, vote aye. Those opposed, vote no. Does anyone wish to change their vote? Madam Clerk, will you count the vote, please?
Madam Chair, you have 14 ayes, 5 noes, 0 present not voting.
Chairman Kiesling, your bill moves on to Finance, Ways and Means as amended.
All right, thank you. Next on the list, we have item 5 has been rolled to the Hill. That brings us to item 29 by House Bill 5. Representative Bolso. Sir, you got a motion in a second. I see House Amendment 6412.
Thank you, Mr. Chairman. Yes, we'd like to put that amendment on the bill.
Very good, members. We have a motion in a second. Any objection to adopting, members, any objection to adopting House Amendment 6412 to House Bill 5? All right, seeing none, all those in favor, vote aye.
Aye.
Opposed, vote no. Ayes have it. Now we're back on the bill as amended. You're properly recognized, sir.
Thank you, Mr. Chairman. Members, this bill seeks to address a serious problem that we have in Tennessee, and the problem is abortion pills being mailed into Tennessee from outside the state, killing unborn children. The most recent data that we have comes from a report from the Society of Family Planning released October 22nd of 2024. And that report indicated that for the period April, May, and June of 2024, on average, there were 460 abortions in Tennessee, deaths of unborn children caused by abortion pills being mailed into the state illegally in violation of both federal and state law, because it's a felony under both federal law, the Comstock Act, and under Tennessee law, our Abortion-Inducing Drug Risk Protocol Act, for anyone to send abortion pills into the state. What this bill does, Mr. Chairman, is it creates a private action, a wrongful death action on behalf of any member of the family of the unborn child against the company that sent the abortion pills into the state. And with that, Mr. Chairman, I'm ready for questions.
Members, any questions for the sponsor? All right, Representative Johnson, you're recognized.
So the fine, who does that apply to? I think initially we talked about carriers, deliverers of the medication, but who does the fine apply to?
Y'all can have an exchange. You don't have to be recognized.
Thank you, Mr.
You're
Chairman. There is no fine in the statute. There is a stipulated amount of compensatory damages that may be recovered by the patient or any member of her family against the company or person who broke the law and sent abortion pills into the state.
Okay, company or person. So I understand company, but when you say person, you're not referring to whoever delivers or that organization or anything. That's excluded, correct?
Yes, that is excluded. We specifically exclude a motor carrier, a freight forwarder, an air carrier, as defined in Title 49 of the U.S. Code. It's just acting upon the actual shipper of the abortion pills into Tennessee.
Okay, is this something that requires a prescription?
It does not.
All right, very good. Members, I have Representative Harris, you're next.
Thank you, Chairman. And to this sponsor, how does this legislation comply with the Commerce Clause of the U.S. Constitution, given that it seeks to regulate transactions occurring between businesses and individuals across state lines?
Representative Bosso, you're recognized.
Thank you, Mr. Chairman. Representative, obviously, you're referring to Article 1, Section 8, Clause 8 of the U.S. Constitution. And I'll point out that when you look at Tennessee's long arm statute in Title 20. It specifically provides for causes of action for tort actions against those who are outside the state who cause an injury inside the state. And our long arm statute has been determined by the U.S. Supreme Court to be constitutional. So I see no difficulty at all with this bill and any portion of the U.S. Constitution.
All right. Next on the list, I have Representative Hardaway. Oh, I'm sorry. Representative Harris, you can follow up?
Yes, so recently, didn't the U.S. Supreme Court have a ruling limiting private enforcement of laws that infringed on constitutional rights? So how does this bill withstand judicial scrutiny regarding its provision allowing private citizens to sue companies for lawful interstate commerce?
Yeah, I'm not familiar with the case that you're referring to, so I'm not able to comment on it.
Right. Thank you.
All right, very good. Representative Hardaway.
Thank you, Mr. Chairman. To the sponsor, I'm trying to get it straight in my head on who can sue. When you say family, is that defined?
Yes, it is. If you look at our wrongful death statute, section 20-5-106A, it defines who is able to bring a wrongful death action on behalf of a decedent. And it generally refers to next of kin.
All right, so it could be grandmama, granddaddy, aunts, uncles, great uncles, great 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 grandmama, all of those would qualify.
I'm not sure the statute goes quite so far as that, Representative, but the first person would be a surviving spouse. If there's no surviving spouse, which in this case there would not be, it would go to the person's children, in which case the person's children could bring an action. Then it would go to a personal representative or to parents, and then to more extended family members. But the litany of those who can bring a wrongful death action is set out specifically in subsection A of the wrongful death statute.
All right, so it's not included in your bill, but it's in current statute.
That's exactly right.
Yeah. And if you're suing under this particular statute, does it preclude you suing under any other state or federal statute?
No, it does not.
And when we look at and I'm not sure, which amendment are we working on? What number?
6412.
Of course, that's the only one that's not on here. And so I'm going from memory here. Oh, no, I do see it. All right, so if the drug itself has, let's say it's been handled by individuals who aren't necessarily in the chain, but let's say that it comes to the house and the husband or the significant other handles the drug. If the woman asks for it, is that husband at that point part of can that husband be sued by another member of the family?
No, not under this bill.
All right. Thank you. Thank you, Mr. Chairman.
All right. Representative Keesley.
Call for the question.
Very good. Question's been called. Any objection? All right. We have objection. Members are on the board for previous question. All those in favor of previous question, vote aye. Those opposed, vote no. Has everyone voted? Anybody like to change the vote? All right, Madam Clerk, if you would take the vote, please.
Mr. Chair, you have 13 ayes, 6 noes, and 0 present not voting.
Very good. Previous question prevails. Members, we're going to be voting send House Bill 5 as amended to health. All those in favor vote aye. Those opposed vote no. Does every member vote? Anybody need to change their vote? All right. Madam Clerk, will you please take the vote?
Mr. Chair, you have 14 ayes, 6 noes, and 0 present not voting.
All right. House Bill 5 as amended is moving to health. That brings us to item 30, House Bill 571, members.
Motion.
By Representative Bolso. Sir, you have a motion and a second on the bill. I'm looking at House Amendment 6824. Very good, members. We got a motion and a second. Representative Bolso, do we need to adopt that amendment? Is that something moving forward?
Yes, we do.
Very good, members. Any objection to adopting House Amendment 6824 to House Bill 571? Seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bills amended and you're properly recognized.
Thank you, Mr. Chairman. Members, this is a bill that I'm carrying at the request of Senator Janice Bowling, and it seeks to protect the privacy and safety of our girls and women in certain specific areas across the state. Specifically, it seeks to require that detention centers, domestic violence centers, correctional facilities, and secondary institutions segregate changing facilities, showering facilities, restrooms by sex so that we have no issue with biological males accessing private areas that which should only be accessed by girls and women across the course of the state. The one change that was made between subcommittee and now is that I noticed that this bill actually contains some overlap in the K through 12 area with the Tennessee Accommodations for All Students Act that was passed back in 2022. So the bill as presented here deals with limitations on higher education, not with K through 12. With that, Mr. Chairman, I stand ready for questions.
Members, any questions for the sponsor? All right, seeing I have Representative Johnson, you're recognized.
Okay, just trying to follow. There was an amendment on here that was removed and you've replaced that amendment. Is that correct?
I would not state it that way. I don't think we removed an amendment. I think we simply amended what was passed in the subcommittee.
Okay, okay. Well, my question would be, what about the concerns, well, some of the bigger concerns that I have heard is in relation to the Federal Prison Rape Elimination Act and how this bill is going to affect that and the lawsuits that will likely come because of the Federal Prison Rape Elimination Act.
Well, I doubt there will be any such lawsuits because if we in this body pass a law that conflicts with federal law that is in fact under the federal court's jurisdiction, then under the Supremacy Clause, the federal act will control. There will be no conflict between the two and therefore no reason for a lawsuit.
But do you see a conflict between this bill and that federal law? I mean, because there are a lot of folks out there, attorneys specifically, who definitely see this conflict.
No, I am not aware of any such conflict.
Interesting. Okay. Well, my other concern, of course, is when it comes to intersex people. There are people born as women who present as women but are biologically considered a male through DNA. Also, the opposite is also apparent, that you present as a male, but you actually are a DNA by female. It's having, and then some folks don't even until puberty. It's not apparent, and that's why we so often wait with physicians and medical care in that to puberty before actually know which genitals that you present as a female, but grow a penis by the time you hit puberty. So there are so many instances that are not defined, and there are as many intersex people as there are redheads. That's how prominent it is. So what is your bill going to, what problems and how are you going to accommodate for these things with this legislation? Because it seems to present a massive host of problems and contradictions and checking people's genitals at the bathroom door. Just explain to me what you're trying to do here.
What we're trying to do is to keep biological males out of changing areas and showering facilities for girls and young women. And I'll point out that for however long we've had a country, and whatever percentage of the population has been intersex, has not created any problem with our institutions segregating women's bathrooms from male bathrooms and women's showers from male showers. So this legislation is a continuing attempt to address a problem that actually does exist, which is biological males who identify as females accessing private areas that should be limited to girls and women. That's the problem this is addressing. It does not in any way affect the kind of problem that the question is raising, which to my knowledge has not been found to be an issue here in Tennessee at any point in time.
It's not been found to be an issue because no one's tried to police our restrooms yet. And now it's happening. And so now it is going to become an issue. People who had these medical conditions their whole life, who could be private about it, will not be able to any longer. And that's just a violation of their privacy. We haven't had problems with any of this. We need to stop policing our restrooms. Let people live their lives, and we can keep our communities safe. We haven't had to do this. I don't understand why we're doing it now. And it's complicating things. It's going to be costly to certain organizations that are going to have to change the way they build everything. And this is, it's ridiculous. We all go to bathrooms all the time. On my way here last week, the women's bathroom was closed at the gas station and I went into the men's restroom and it was no big deal. A month ago, I was waiting in line at the girls' restroom and a guy came out. I survived. It was okay.
All right, we good. Next list, I have Representative Hardaway.
Thank you, Chairman. Need some clarity on the actual facilities which could be or should be provided. Is there any mention in here of a third bathroom or restroom for family use?
Yes.
And what is that reference?
Well, it's a reference in several sections of the bill that refers to there being a men's bathroom, a girl's bathroom, or a family restroom.
Does it require the same or merely address it if that third facility, bathroom, restroom is available?
It does not require such a restroom. It simply designates that members of the same family may obviously share a multi-occupancy restroom.
And if there's not a multi or a family facility available, how do you determine where that family, if you've got little kids, how do you determine where they go without getting prosecuted?
The way that folks have done that for over 200 years in this country.
Which is?
Which is, in this particular case, I mean, you can read the legislation specifically on page 7, where it says specifically the section does not prohibit institutions from accommodating young children or elderly individuals in need of physical assistance when using restrooms, changing facilities, or sleeping quarters.
And young would be defined as?
the statute does not define the term young, but just in terms of using an ordinary and common understanding, a young child would be a child that's 2, 3, 4, 5 years old.
But that's not determined in the bill itself.
Correct. There is no definition of the term young in the bill.
Is there a definition anywhere else in statute?
Not that I'm aware of.
Thank you. Thank you, Chairman.
Thank you, sir. Next, let's have Leader Lamberth. Previous question has been asked. It's properly motion, proper second. There is objection. Members were on the board. Previous question. All those in favor of previous question, vote aye. Those opposed, vote no. As every member voting, would like to change your vote. All right, Madam Clerk, if you please take the vote.
Mr. Chair, you have 16 ayes, 6 noes, and 0 present not voting.
All right, previous question prevails. Members are going to be voting to send House Bill 571 as amended to calendar and rules. All those in favor, vote aye. Opposed, vote no. Excuse me. Has every member voted? Anybody like to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 16 ayes, 6 noes, and 0 present not voting.
Very good. House Bill 571 as amended moves to calendar and rules. Very good. Thank you. Okay. All right, members, that brings us, if we could, without objection, if we could move to item 58, members, House Bill 580 by Chairman Doggett. Sir, you have a motion and a second, and members, Chairman Doggett has House Amendment 6511 as well. You got a motion and a second there. Chairman Doggett, is that the amendment you need to move with?
Yes, sir, it is. It does make the bill.
Okay. Members, any objection to adopting House Amendment 6511 to House Bill 580? All right, seeing none. All in favor say aye. Aye. Opposed say no. Ayes have it. Now we're back on the bills amended, and you're properly recognized.
Thank you, Mr. Chairman and committee. Many of you may recall the Debbie Marie Domestic Violence Act that we passed last year mandating GPS monitoring for domestic violence arrests that involved aggravating assault offenses. This amendment cleans up items from that act that needed clarity. And additionally, this amendment seeks to provide standards for GPS monitoring companies who provide these services in our great state. These companies have an important job to do, and the people performing these services need to meet certain requirements to be qualified. We began working on this in August of last year and have met with numerous stakeholders consistently to finalize the amendment that you have in front of you today. Mr. Chairman, I'm happy to go through all the sections of this bill one by one if needed, but if not, I do have someone here that has requested to testify on this bill.
And that is correct. I have Diane Lance on the list. Ms. Lance, if you want to step on up here. Members, any objection going out of session here from Ms. Lance? All right, seeing none. Ma'am, just have a seat anywhere you'd like. The red light will come on your mic there, and you'll have 2 minutes. And just please introduce yourself, and it's all yours.
Great. I'm Diane Lance. Pull it down. Is that better? Thank you. I'm Diane Lance. I'm a former prosecutor here in Nashville, specializing in domestic violence and violent crimes against children. I currently am the director of Metro Government's Office of Family Safety, which oversees the city's 2 family justice centers, which are part of the Tennessee network of 14 family justice centers, because Tennessee has the most family justice centers per capita across the country. It's something I think we're all really proud of. And that is, the family justice centers are the collaboration model for preventing domestic violence homicides. I want to thank you for allowing me to speak today. And also thank you for the Debbie and Marie Domestic Violence Protection Act. It has made a really big difference. The fact that it requires GPS monitoring for some of the most dangerous and predatory offenders in domestic violence that we see. Unless a magistrate now finds proactively that the defendant is no longer poses a risk to victim safety, and to public safety in general. And we're seeing the effectiveness of this statute every day. We are noticing that our magistrates are working really hard to make sure that they have access to all the information that they need in order to make that proactive determination if victim risk remains and public safety safety risk remains. They are now accessing local records, national records on a more regular basis, and able to review lethality assessments, that evidence-based tool that patrol officers across the state are using that ask a battery of questions that will tell that officer if that victim in front of them is at high risk of being killed or seriously injured by their offender. In Nashville, we looked at, if we look at the past 7,000 lethality assessments that our patrol officers have done, 50% are coming back reporting that that offender in front of that police officer is a strangler. And the stranglers are the killers, and the stranglers are on their way to doing that next big act of killing their offender, just like in that Debbie and Marie case. You look at the history of strangulation, the history of other violent acts that have happened in the past. If you are a strangler, you're at 750 times more risk as their victim of being killed. They are the mass shooters, and they are often the ones that are the cop killers. They have a history of those things. So this amendment is what we're hoping to make sure that the last part of it, Section 7D1, is the part that I am here about, and that is the one that requires a show cause hearing.
All right, ma'am. I'm sorry, you're quite a bit past your time there. So, but we'll have time for questions. Members, we have any questions for our guest? Representative Hardaway, did you have your hand up?
Yes, sir. I was interested in what the rest of your
I so appreciate that. Section 7D1 requires a show cause hearing before the electronic monitoring company will be able to discontinue. So in the instance of where the defendant is on GPS monitoring and they stop making payments on that electronic monitoring, the company can't just discontinue it with no notice to the courts at all. So a show cause hearing in that amendment would make sure that the fact that the GPS monitoring company wants to end that contract, the judge will be noticed, there'll be a show cause hearing, and then hopefully procedurally, locally, the victim will be notified as part of that show cause hearing. And that notice is essential to keep the victim safe. If the courts need to know that the defendant's in compliance, the victim needs to be able to be assured that they're being actively monitored and that they're going to be notified if there is a change in that.
Very good. Members, any questions for our guest? Leader Lambert, you're recognized.
Thank you. Just a statement. I want to thank you for the work that you do. It's extremely important in Davidson County, and there's no telling how many thousands of lives that have been saved because of the work you do every single day. And it's just, and members, if you've never been over and seen the facility they have and how they guide victims and survivors of violence through the system in the court system at Davidson County, it is impressive and quite frankly has several aspects to it that are best practices that should be used statewide. So just want to thank you for your work.
Invite everyone to either visit your local family justice center or ours here in Nashville.
Representative Hardaway.
Thank you, Chairman. And thank you again for the work you do. And I understand you may work with one of our former colleagues, Darren Jernigan.
Yes.
Yeah. Okay. So the data collection and analysis, is that a responsibility that you have? Is there a clerk in criminal court or one of the court clerks, AOC? How do you get your data and who does the analysis?
Such as the data I just presented about the lethality assessment, that type
Yes,
of
ma'am.
data. We keep that internally. It's one of the benefits in Nashville that we have, that this work is housed under a standalone metro department, and that we have the resources and the capacity to really collect the data, not just from our work, but from our partner work. So Family Justice Center is a collaborative where you house the work of multiple partners. I like to think of it as, a great recipe, and there are 10 ingredients in that recipe, and that's all housed in one place to be able to make the perfect sauce that provides what the victim needs. So they're not sent all over town to get the services they need. So we collect our own data from all our partners. We collect police data, prosecution data to help guide our work, as well as our many nonprofit partners.
So does there need to be some uniformity statewide in how data is collected and analyzed?
Yes,
And
absolutely.
reported?
absolutely. A consistent database, certainly across family justice centers across the state, that's feeding the information into that would really help tremendously. Right now, the Office of Criminal Justice Planning under the Finance Department in the state, which is a wonderful group to work with, but they are limited in the amount of data they can get by the amount of data each family justice center can track. And if we were all on a consistent system that worked together to gather, again, the information from not just the work that your independent organization does, but all the partners working together do, that would be really helpful.
All right. Well, I'm sure that the bill sponsor, Chairman Doggett, is going to be back next year with something that addresses that. And Mr. Chairman, I'd be negligent if I didn't express appreciation to our former colleague, Judge Carter, for the work that he did over the years to kind of lay the foundation and keep the momentum to get us to this point. So, and thank you, ma'am,
Thank
again.
you.
Certainly. Chairman Doggett.
Thank you, Mr. Chairman. Thank you for coming and meeting with us. And members, I'll say that when we started this process last year, and then we come back in and we're working to make some clarification changes. And it's rare that you get someone that is so excited about what you're doing to call. And our former colleague, the Honorable Darren Jernigan, reached out and he said, I've got this lady that has some great ideas. And so some of the things in which we incorporated in this amendment come from there. And we hope that this makes it even better and provides additional safety and security to all the victims of domestic violence. Thank you for your time and testimony.
Very good. Members, any additional questions for our guests? All right, seeing none, any objection, going back into session. All right, ma'am, thank you so much for being here. Back in session. Members are back on House Bill 580 as amended. Any questions for the sponsor? All right, seeing none, ready to vote? All right, members, all those in favor, without objection, all those in favor of moving, all those in favor of House Bill 580 moving to calendar and rules as amended, vote aye. Those opposed, vote no. Any member voted? Every member voted. Anybody need to change the vote? All right. Madam Clerk, you take the vote.
Mr. Chair, you have 20 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 580 as amended is moving to calendar and rules. Members, if you don't mind, let's stay down near that end of the calendar. If we could take up item 59, House Bill 1257. Chairman Doggett. Sir. And then he also, members, has House Amendment 6382. You got a motion and a second, and that's an amendment we adopted in subcommittee. Just need to move it on. Any objection to doing so? All right, seeing none. All those in favor of adopting House Amendment 6382 to House Bill 1257, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized, sir.
Thank you, Mr. Chairman and committee. This is a cleanup bill. I know we use that. It really is. It is. It's we're cleaning up the expungement statutes. It's just a reorganization. We're not. We did remove some of the duplicative language that was in there, but we have. Did we adopt the amendment? Yes. Okay.
Yes,
Sorry.
sir.
I'm sorry. Yes.
We're on the bill as amended.
Thank you. So that's what it is. We went through. Now there is a couple things that have changed. I know that in years past in the code. You could get an expungement for certain offenses for committing the offense, but the attempted portion of that were not expungible. Now, in some places, it was interpreted that's the way it was. We just made that clear in this. So we just completely reorganized the expungement statute, hopefully to make everything just flow a lot more cleaner and smoother so that in the 95 different counties of our state, judges and attorneys can go to this and see that this is what the legislature's intent was the whole time. And with that, stand ready for questions.
Members, any questions? I have Representative Travis. You recognize? Question's been called. Any objection to the question? Seeing none. Members, looks like we'll be voting to send House Bill 1257 as amended to calendar and rules. All those in favor vote yes. Those opposed vote no. Has every member voted? Any member wish to change their vote? Madam Clerk, would you please take the vote?
Mr. Chair, you have 20 ayes, 0 noes, and 0 present not voting.
Very good. Members, House Bill 1257 as amended moves calendar and rules. Members, that brings us to item 57, We're working our way back up the calendar. Item 57, House Bill 528 by Chairman Doggett. So you got a motion and a second. We have House Amendment 6716, which we adopted in subcommittee. Members, got a motion and a second on amendment. Any objection to adopting House Amendment 6716 to House Bill 528? All right, seeing none. All those in favor, vote aye or say aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. You're properly recognized, sir.
All right. Thank you, Mr. Chairman. This bill requires professional bail bondsmen and agents of those insurance companies making appearance bonds in criminal cases to assess a premium fee of 10% of the amount of the face value of the bond rather than no more than 10%.
Members, any questions? All right, seeing none, we're ready to vote. Any objection to the question? Seeing none. All right, all those in favor of sending House Bill 528 as amended to calendar rules, vote aye. Vote yes. Those opposed, vote no. Does every member voted? Any member want to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 17 ayes, 2 noes, and 1 present not voting.
Very good. House Bill 528 as amended is moving to calendar and rules. Members, that brings us to item 56. I know we're working backwards, but that's House Bill 1353 by Chair Lady Littleton. Ma'am, you got a motion and a second, and also I'm looking at House Amendment 4512. Members, so I got a motion and a second. Any objection to adopting House Amendment 4512, House Bill 1353, members? All right, seeing none. All those in favor, vote aye or say aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized, Chair Lady Littleton.
Thank you, Mr. Chairman. House Bill 1353, as amended, clarifies the offense of retaliation for a past action, expands the list of individuals involved in the judicial process to include a former judge, a former law enforcement officer, a former district attorney general, a former assistant district attorney general, and an employee of the judge, a former clerk, a current or former district public defender, a current or former assistant district public defender, and an employee of the district public defender. With that, I'll
Members,
take questions.
any questions for the sponsor? Seeing none. Any objection to the question? All right, seeing none. Members, like we're ready to vote. Send House Bill 1353 as amended to Finance, Ways and Means. All those in favor vote yes. Opposed, vote no. Is there a member
Yes, I
voted?
should vote.
Any member wish to change their vote? All right, Madam Clerk, if you take the vote.
You have 21 ayes, 0 noes, and 0 present not voting.
House Bill 1353 as amended is moving to Finance, Ways and Means. All right, members, item 55, House Bill 1352 by Chair Lady Littleton.
Second.
Ma'am, you got a motion and a second, properly recognized on the bill. We have House Amendment numbers 5267. Members, any objection to adopting House Amendment 5267 to House Bill 1352? All right, seeing none, all those in favor say aye.
Aye.
Opposed, say no. Ayes have it. Now we're back on the bill as amended. Chair Lady, you're recognized.
Thank you, Mr. Chairman. As amended, this bill requires a person convicted of a Class B felony offense of the aggravated sexual battery to be sentenced as a Range 2 offender if the victim was less than 18 years of age or was mentally defective, mentally incapacitated, or physically helpless, allows the defendant to be sentenced as a Range 3 offender if appropriate.
Very good. Members, do we have any questions for the sponsor? Questions have been called. Any objection to the question? Seeing none. Looks like we're ready to vote to send House Bill 1352 as amended to calendar and rules. All those in favor vote aye. Opposed, vote no. Has the member voted? Any member wish to change their vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 1352 as amended is moving to calendar and rules. Members, that brings us to item 54, House Bill 769 by Chair Lady Littleton.
Motion.
Second.
Ma'am, that's a motion and a second, and I don't see an amendment traveling with this bill, so you're properly recognized.
Thank you, Mr. Chairman. This bill creates an offense for a person to knowingly possess, distribute, or produce technology, software, or digital tools designed for the purpose of creating material that includes a minor engaged in sexual activity or simulated sexual activity that is patently offensive.
Very good. Members, do we have any questions for Chair Lady Littleton? Representative Johnson, you're recognized.
Yes, so I'm trying to understand, it said tools. So like, basically I could probably do that on my phone. And so is there a specific, there has to be something specific like a program, or does it differentiate between technology that could do it or technology that's designed to do it? That's the question.
Chair Lady?
This bill does not prohibit technology and software like Photoshop or other similar programs with a legitimate purpose.
So what specifically is what has to be present in order to violate this law?
It only applies to technology, software, and digital tools made with the purpose of creating child sex abuse materials.
So that's their only purpose, is that, not using something that could have another purpose, but also can do that. Thank you.
Members, any additional questions for the sponsor? Any objection to the question? All right, members, looks like we're ready to vote. All those in favor of sending House Bill 769 to calendar and rules, vote yes. Opposed, vote no. Has every member voted? Any member wish to change their vote? All right, Madam Clerk, please take the vote.
Mr. Chair, you have 21 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 769 is moving to calendar and rules. Members, that brings us to item 53, House Bill 314. We've got a motion and a second. Members, we also have House Amendment 4898. We've got a motion second. Any objection to adopting House Amendment 4898 to House Bill 314? All right, seeing none, all those in favor, vote aye.
Aye.
Opposed, vote no. Ayes have it. Now we're back on the bill as amended. You're probably recognized, Chair Lady.
Thank you, Mr. Chairman. This was brought to me by the treasurer, and it requires the state treasurer to compare the maximum award limit for the criminal injuries compensation program with the national average of the maximum award limit, rounded to the nearest $100 each year, beginning January the 1st rather than October the 1st of each year, and requires by June the 30th of 2025 the treasurer to publish on the Treasury website the maximum compensation award determined for claims filed for crimes occurring on or after July 1 of 2025.
Members, question's been called. Any objection to the question? All right, seeing none. Members, will be voting to send House Bill 314 as amended to calendar and rules. All those in favor, vote aye. Opposed, vote no. Has everybody voted? Any member wish to change their vote? All right, Madam Clerk, if you would, take the vote.
Mr. Chair, you have 22 ayes, 0 noes, and 0 present not voting.
Very good, members. House Bill 314 as amended is moving to calendar and rules. And that brings us up to item 50. I saw House Bill 1371, Representative Chisholm, I believe, came into the room. Very good, sir. You got a motion second. I don't see any amendments here, so you're probably recognized.
Thank you, Mr. Chairman and committee. House Bill 1371, it aims to update our revenge porn statute. The Memphis Police Department 6 Crimes Unit brought this bill because of the dangers of a non-consensual intimate image distribution. So what this bill does, this bill clarifies that a person commits the offense regardless of whether or not the person who distributes the image was a party to the original image being shared. So with that, I stand by for questions.
Very good. Members, do you have any questions for Representative Chisholm? Seeing none, any objection to the question? All right, seeing none, looks like we're ready to vote. Send House Bill 1371 to Finance, Ways and Means. All those in favor, vote aye. Opposed, vote no. Has everybody voted? Anybody wish to change the vote? All right. Madam Clerk, if you would take the vote, please.
Mr. Chair, you have 20 ayes, 0 noes, and 1 present not voting.
Very good. House Bill 1371, sir, is moving to Finance, Ways and Means.
Thank you, Mr. Chairman and committee.
Thank you. All right, members, if we could, I know we're hopping around a little bit today, but we have had Representative Parkinson patiently waiting. We previously moved item 22, House Bill 1131 to the Hill of today's calendar. If we could take that House Bill 1131 by Representative Parkinson. Sir? So you got a motion and a second. Also, you have House Amendment 4305, sir.
Yes, sir.
Members? You got a motion and a second on the amendment. Members, do we have any objection to adopting House Amendment 4305 to House Bill 1131? All right, seeing none. All those in favor, vote aye. Aye. Opposed, vote no. Ayes have it. Now we're back on the bill as amended, sir.
Thank you, Mr. Chair, and thank you, committee. And members, I ask that you remain open in this discussion. And I further ask that you see this discussion from the lens of a child who has absolutely no responsibility regarding what the adults are arguing about, but the children are the victims here. Think about this. Simply because the adults have dissolved or are dissolving their relationship, it does not abate the relationship that the child has with his or her mother or his or her father. God gave a child two parents, and they need both in most cases for balance. When we as a society remove one of the child's parents from the child's life, we take the child out of his or her natural balance. It is the child's God-given right to have access to both parents whenever possible. We know that there's been a tremendous lobbying effort by the Bar Association, who I respect. Their family court division is against this bill. However, I asked the trial lawyers their thoughts on it. They had no issue. I also called and have spoken to several judges across the state, both rural and urban, from across the state, and every judge that I spoke to said this bill in no way binds their hands in regards to outcomes. In fact, this bill actually frees them up to look at the entire picture that speaks to the best interests of the child. And that's what we're here for. The question is, what is in the best interest of the child? I submit to you that a child has the right to both his or her parents, and that is by far, from the standpoint of the child, is in his or her best interest whenever possible. That's the key, whenever possible. While this bill is not a fix-all, it is simply a start with an important declaration. That declaration says it is in the best interest of the child to have both parents involved in the child's life when possible. For decades, through policy at the federal level and at the state level, these policies have been levied and have destroyed the family structure in our country and in our state. An example of that is the federal welfare laws that came from the 50s, 60s, and 70s that said if a woman receives assistance from the federal government, then the father could not be present in that household. The state would then follow suit, forming and supporting those ideas, and kept some parents out of the life of the child. I ask you to look at the outcomes that these older policies have delivered in our society. Look at the state of our youth. Look at the youth violence numbers and the egregious levels and types of violent acts and crimes being perpetuated by our youth. Look at the elevated levels of trauma. Look at the elevated levels of mental health issues in our youth. Look at the lifestyle choices, joining gangs, etc. What this bill does, it simply says that, one, it establishes a rebuttable presumption that joint legal custody and equally shared parenting time are in the best interest of the child. Now let's define rebuttable presumption. A rebuttable presumption, based on the definition that legal gave me, and if we want to go out of session to legal to say it themselves, you'd rather take their word for it, I'm okay. A rebuttable presumption is simply a starting place absent evidence. Let me say that again. This is important, a rebuttable presumption is a starting place absent any evidence. So what that looks like for those of us that are visible, before the parties come before the judge or the courts, everything is in the middle. Once the parties come before the courts, evidence is presented, the judge has all discretion based on that evidence presented to go to one parent or the other, or to go in the middle, up or down, whatever that judge decides. We are not binding the judges. We are, and I'll say it again, and I've spoken to the judges, and this is what they've told me. Rural and urban judges alike across this state. This legislation in no means binds us in regards to our outcomes. What this bill does is it establishes parenting time and joint legal custody as a starting point. That's it.
All right, thank you, sir. That's your 5 minutes. Members, any questions for the sponsor? We do have some folks signed up to testify. Representative Garrett, you're recognized.
Mr. Chairman, I don't want to, if there's folks to testify, I'd rather hear from them first. If they're going to testify anyway, then I've got So may I have some questions for them as well?
That's right. Yeah, I had Representative Parkins indicated we have four folks that he'd like to bring up, testify in support of, and then we have two folks to testify in opposition. So members, we're going to go to a session here from our guests. Any objection? All right. If we could bring up Mr. Music and then Mr. Spanos. Blake, I'm sorry. Yes, my bad. I apologize. All right, cool. Ms. Music, we'll start with you, and then Mr. Spanos will. So you all have your mics will pop on. If you would just introduce yourself. Red light will come on. You have 2 minutes apiece.
Okay.
Thank you.
Thank you, Tennessee House Judiciary Committee, for your time. My name is Dr. Vargas Music, and I am speaking for the Tennessee Safe Parents Organization, which represents 500 mothers and fathers across Tennessee. First, I would like to point out that this bill's caption did not include any wording about custody arrangements. The caption text was about child support, and the amendments still have not been posted on the Tennessee government website. The manner in which this bill has been presented violates the rights of the Tennesseans, since we cannot know about it or have access to the wording that is being heard today. Moving on to the bill, TSPO asserts that the best scenario for children is equal access to healthy parents. 9% of cases that go to court are shown to involve domestic violence and child abuse. However, there is an alarming trend facing parents in this state and in our nation called parental alienation. This term was coined by a man who used the concept as a way to counteract claims of abuse. The concept of parental alienation has put family law into a frenzy. You will hear from court professionals like William Bernay, who use this term in custody evaluations to force children into reunification programs where children are traumatized and compelled to recant allegations of abuse. According to research published in the Journal of Family Violence, these custody evaluators, including Bernay, may have financial ties to these programs, such as the one called Turning Point, which children in Tennessee are ordered to. Sitting in the front row behind me are 2 little girls. The older girl was severely abused, and I cannot say what kind, but you can imagine. DCS substantiated the abuse. However, because the father claimed parental alienation, the court ordered the girls into reunification therapy, despite the protests of DCS, the Children's Advocacy Center, and the children's pediatrician. In my case, restraining orders, medical neglect, child abuse, domestic violence, and my child's PTSD were all ignored by the courts. Tennessee Safe Parents Organization is asking that this honorable committee require sponsors of this bill to bring our organization to amend this bill. Specifically, we propose language that allows for evidence of abuse to a parent, other person, child, or other siblings to be guaranteed entry into any custody case, addressing the res judicata legal argument that currently prevents evidence of abuse from being entered and applied. We request that this bill be rewritten with DCS, TBA, TSPO, and the Tennessee Coalition for Domestic Violence.
Oh, thank you, ma'am. You're right on time there. Sir, if you would introduce yourself, you have 2 minutes.
My name is George Spanos. I am the chair of the Tennessee Bar Association's Family Law Executive Committee. My practice is entirely focused on family law, and I am a certified family law advocate here in Tennessee. I have spoken with over 100 different attorneys who practice family law across the state, from Memphis to Knoxville to Chattanooga. I've talked to judges across the state. Not a single person has told me they support this bill. Every person is objecting to it. This bill causes significant problems in family law. The presumption that's being put in place will cause detrimental effects to how cases are tried. And we've seen this evidenced in other states, most notably Kentucky, who I've looked up their information because they have it all posted through their administrative offices of the courts. Our fears are that the same thing will happen here that happened in Kentucky, that divorces will decrease, parents will, on both sides, mothers and fathers, will be concerned about divorcing and having another parent have a 50-50 parenting time when they are in situations of abuse. If you look in Kentucky statistics, this is what happened. Orders of protection, domestic violence, and similar filings exponentially increased over a 6-year period, some of them over 100%, never to come back down, others up to 88%. This bill will cut the legs out of the best interest calculation because this bill presumes that the best interest is already been found. If it did not do that, it would not require findings of facts by judges to explain why they did not do 50-50 with equal parenting time, but require no findings of facts to do 50-50. This is a one-size-fits-all solution to probably the most important factual determination a judge can make in a custody case. What is the best interest of the child? The current standard is appropriate. We start with a blank slate. By law, gender cannot be a basis for parenting. By law, already the courts are to maximize each parent's parenting time with the minor children. This is already in place. If the intent is to make sure people are treated fairly and equally, our laws are doing that now, and the facts to each case, to each child, are what the courts analyze.
Very good. Thank you. Your time's up.
Thank you.
Members, any questions for our guests? Representative Johnson, you're recognized.
Yes, and thank you so much. I like the way you said start with a blank slate, because I think that the consideration here should be in the child's best interest. And if you start on a presumption of 50-50, then you're not considering the child's best interest. And so I think that that is a really important statement. Certainly, we want a child to have access to both parents, but if in situations like we know happen, we're presuming everything is okay. And to make somebody prove that it's not initially in custody, to me, is problematic. I think that it should be a blank slate, and we should always start first with considering what the children need. And so I appreciate that. And what you were saying about Kentucky, so what you were saying was that this type of legislation or this legislation caused people to stay married who were in abusive situations, whether it was a spouse that was being abused or a child that was being abused. But for fear of losing custody because of that 50-50, or at least their child being with a dangerous person 50% of the time, they chose to stay in abusive relationships. Was that the result that you talked about?
Can I speak on that?
Yes, but let me
Okay.
ask him first, and then we'll let you do that as well.
Looking at the data, that's what it would indicate. Also from personal experience in family law, these are things that people tell me already. When I see abused spouses, abused children, parents are already afraid of going into the system and creating a situation where they're not with their child at all times, whether they were the abused person or the child was, because they will no longer be there to either protect the child, or their fear the child will be abused or be the instrument of further abuse to them. And that fear is very palpable, and it already exists with people today. I've met with people who I've had to tell, you need to file because you're not safe. And I only do that when it's physical abuse or something worse. And I don't have to say it often, but I already have to tell people that. And it's very disheartening, it's sad, and it's difficult. And people will be, I'm afraid, more concerned with this, and that's what my peers agree with. They are very concerned with this bill. I can tell you from experience that an attorney told me specifically that she would not have filed for divorce if this bill was in place, because she would not put her children at risk for this very reason. Thank you.
Thank you. And you might have some personal experience.
So I addressed the term parental alienation. Studies, there have been multiple studies over the last 10 to 15 years that show men use this term. I say men, men are also abused. However, we know that 85% of domestic violence is against women. So when I say the women, I mean both, but primarily women. When men use parental alienation as a counterclaim to domestic violence or child abuse, studies show that they get custody in 73% of cases. Common sense tells us that our courts are protecting our children, right? We have this, we're saying, oh yeah, we can deviate. That is not what the courts are doing.
Okay. And you also mentioned something about some of information being prevented from being presented.
When I started my case, I had a restraining order. My daughter had multiple custody evaluations by a child psychiatrist. who was able to tell in her play therapy that she had witnessed domestic abuse, was likely sexually abused, and this was substantiated. She went to the Children's Advocacy Center and later a therapist. Over the course of 6 years, 3 different independent psychiatrists and therapists had come to the same conclusion. In my case, she said she wanted to die because she did not want to go to her dad's house. I brought this to the judge. The judge awarded my ex-husband 50-50 custody in a Zoom hearing that I was not allowed to attend.
Thank you.
Members, any additional questions for our guests? All right, Representative Powell.
I guess, ma'am, if you could tell me, since this happened under the current law, like what sort of steps would you recommend? Or, I mean, if this did happen under current law, what do you see as like a adequate solution?
Are you speaking to me or to?
To you. I'm sorry. Yes, ma'am.
An adequate solution?
Yeah.
First, we are asking that parental alienation be removed from being allowed to be used in the court system. They also use terms such as gatekeeping and enmeshment. We would also like to limit reunification camps, which is another thing that they send children to. A reunification camp is they send these children to camps with their abuser. They say that it's a fun wilderness camp. These kids have come out of there saying that they are essentially put into jail cells. They are not allowed food, water, and they have to sleep in their own feces and urine until they say that they have not been abused. Then they have this in recordings and use this in court testimonies. So we would like to remove the use of reunification camps, reunification therapy. In the case of the girls behind me, she has been in a case for 5 years and she has substantiated abuse. And the judge continues to order the children to reunification therapy with their father. And these girls are terrified. We want to see reunification completely removed from this state. We also want to make sure that all judges, court professionals, attorneys, GALs are appropriately educated. And we also want to make it clear that we are for shared parenting. This is an unintended consequence of setting the bar at 50-50 because it is already so hard for us to prove, and not even prove. I mean, I had proof. I had police reports. I had restraining orders. The courts are not listening to it. So how do we make our judges obey the law? I can't tell you because when I tried to file an appeal against my judge, I was told that it would take a year and it would go right back to the same judge. So how do I feel comfortable filing an appeal against my judge for improper conduct, knowing that it's going to go right back to him?
All right, members, any additional questions for our guests? We do have 4 more that we need to pull up here. We're running short on time as well. So any additional questions for the guests we have up here? All right, seeing none. Thank you all so much.
Thank you.
Members, if we could have Mr. Harvey, Mr. Ludwig, and Mr. Burnett. All right. Gentlemen, just have a seat anywhere you looks comfortable to you, and then we'll start with you, sir, on my left. We'll start with you. If you would just introduce yourself. Each of you, your mic's on right now. You have 2 minutes to introduce yourself, and you got 2 minutes. Each of you all will have 2 minutes to speak. So go ahead.
Okay, thank you. Members of the committee, my name is Mark Ludwig. I'm an Uber driver from St. Louis, who my story ended up going viral. I was relegated to basically an every other weekend father after having a extensive background working with special needs kids, foster kids, and teaching kids in my church. I was pretty well known in the St. Louis area. My story went viral. It had over 120 million hits. So I've got over 1 million followers on social media, obviously not because of me, but because the story resonates. Half of all marriages end up in divorce. Half of all kids are born out of wedlock, and we have a lot of broken homes around the country. And what happens to a child is they have the dual trauma. Trauma number 1, mom and dad aren't together. They don't understand that, but they're confused by that. Now, trauma number 2, why is one parent the inferior parent and one is the superior parent? Why does one parent have to beg for permission to get extra time? Why is one parent always here? And the challenge with that is when you get into the teenage years, when that child starts having behavioral problems, it's very hard to discipline a child when that child has been raised to believe that this parent is inferior. And all of a sudden, oops, we need them back in the life now that they're a teenager. And that's why we wind up with so many problems all around the country with behavioral problems, drug abuse problems, incarceration rates, violent crime rates, high school dropout rates. The one common ingredient, they grew up without a parent. Now, it's usually the father, but I'll fight just as hard for a mother because I'm not fighting for the mother or the father. I'm fighting for the child. And unfortunately, we have a system right now that focuses on the parent. It's one parent fighting against each other. If instead we could focus on the child and say, wait a minute, that child needs both parents. Each parent adds value in a different way. And so what happens right now, I get a lot of my followers that say, Mark, I didn't have near as much animosity to the other parent until I walked into my family law attorney and they said, look, in our state, you're not going to get 50-50. So I need you to dig up dirt on why you're the better parent. I don't think there is a better parent. Maybe different parenting styles, but that's why I think it was designed. And could you imagine how different it would be if that same parent would walk into a family law attorney's office and they'd say, you know what? In our state, unless you've got some abuse or some overriding reasons to not do 50-50, you better learn how to co-parent and get along, put that money in your own kid's college fund instead of my college fund, and clear the courtrooms of 90% of the cases that shouldn't be.
All right, thanks, sir. You're 2 minutes up. Sorry, you're up now. You're 2 minutes up. We'll have time for questions.
All
Sir,
right.
if you just introduce yourself, you'll have 2 minutes as well.
Good afternoon, esteemed members of Tennessee State Judiciary Committee. My name is Antonio Harvey, and I stand before you today as a father and a current school administrator in Memphis-Shelby County School, who has been dedicated my whole life to supporting children. Over 300 of them every day at my school. Yes, despite my commitment to nurturing young lives, I was denied 50-50 custody of my own children. I'm here to urge you to pass the House Bill 1131, not just for me, but for every child in Tennessee who deserves equal time with both parents. As a father, I know how much kids light up when they spend time together, whether I'm helping them with their homework, cheering them on in their games, or just listening to their hopes over a quiet evening. As a school administrator, I see this multiplied across hundreds of students. Kids with involved parents, I mean both parents, consistently show better grades, fewer behavioral struggles, and stronger emotional health. Presumptive 50-50 custody isn't about parental rights. It's about giving our children a chance to thrive with a full support of mom and dad. Childhood is built on memories, fishing trips with dad, baking cookies with mom, the little things that become big memories. For my own children, I fought to be more than a weekend visitor because I know their experiences require time and presence. When the law doesn't start with equality, it risks stripping kids of half of their story. I want my kids to remember both parents tucking them into bed, both teaching them how to read, how to ride a bike, and that balance fosters security and trust, things every child needs to grow strong. I work with children every day, and I see their potential, their struggles, and their joys. I was trusted to guide and support over 300 students every day, yet I wasn't trusted with equal time to raise my own children. That's a disconnect that we can fix. Yes, there are cases where 50-50 custody isn't safe or feasible. I trust our courts to handle those cases wisely. But starting with presumptive.
Thank you, sir. Your time's up, and we'll have time for questions. Sir, your mic's on. You can introduce yourself there,
Thank you.
and we have 2 minutes. Thank you.
Chairman, committee, I don't have anything written. I speak from the heart. I listen to the folks behind me. They have valid points. There's always going to be insinuating circumstances, always. I came from a divorced parents in Kentucky, where I'm from. My mom, my stepdad, and my dad got along great. Shared me. Everything was fine. Later on, I got married. Got a divorce. We didn't go out to dinner together, but we raised our children together. I had no qualms about her new boyfriend or new husband. And I see it every day. But I'll tell you one thing that really, and the gentleman brought it up, I actually was the president of the basketball league in Laverne. I coached football and baseball for 20 some years. and from 5 till 18. And when I'd see them little fellas running off that field or off that court with sweat beads coming down their face, smiling, and then I'd look up at game time and they wouldn't be there. What's going on? Well, it's his mother's weekend, or it's his father's weekend. They would not do it together. Now I don't know what the reason, but what I do know is things change. Me and my ex-wife, we did a 50-50. That every other weekend nonsense, let's be realistic, let's call it what it is. As a child, if you loved your mom or your dad and you only got to see them every 12, 14 days, think about that. Those of you who have parents still living, do you feel comfortable about not seeing them every other week? Now, like I said, there is circumstances. That's up to the court, so that's not up to this body.
Thank you, sir. You're 2 minutes up. We'll have time for questions. Sir, if you would go ahead and introduce yourself, your mic it's on now. So if you'd be sure to introduce yourself.
Yeah, hi, thank you, Mr. Chairman and committee. I'm Dr. Bill Burnett. I am a child psychiatrist and forensic psychiatrist, was on the faculty at Vanderbilt for 20 years. I'm retired, so they made me an emeritus professor of psychiatry at the medical school. So actually, one of the previous witnesses mentioned me because of my interest in parental alienation, which is fine. But I'll just point out that as far as I can tell, parental alienation and also reunification programs don't have anything to do with this current bill. That was just totally extraneous information. I want to summarize for you why I'm in favor of this bill. And it's not my opinion. It's not off the top of my head. It has to do with what is the research. There's been 30 or 40 years of research on shared parenting, and it shows the following. First of all, children of divorced parents raised in shared parenting arrangements do as well or better than other children of divorce, especially in terms of how they have relationships. When I say research, these are big studies. They're huge. Some of these studies involve 100,000 children, some of whom are in shared parenting, some of whom are in different arrangements. It's a basic premise. We all believe that it's advantageous for children to have healthy relationships with both parents. The research shows that children raised in shared parenting have better and more enduring relationships with their mothers and their fathers. You can study this. I can explain to you how they do those studies to show that. Now, it's interesting that for children to benefit from shared parenting, it's not required for the parents to agree or to be totally non-hostile or to think it's a good idea. That's another thing that's been shown in research, that even when parents don't agree in the beginning, that as the shared parenting progresses, there's more and more agreement, there's less anger, there's less hostility, and there's less returning to court. Now, I'm not saying that violent people should be given shared parenting. I'm not saying
thank
that.
you, sir. You're 2 minutes up. We'll have time for questions. Representative Hardaway, you're first on the list.
Thank you, Chairman. First, I was interested, I was captivated by Mr. Harvey's story. Can you finish out what you were sharing?
Yes, sir. At the end, I was saying that I trust that our courts can handle this wisely by starting up presumptive equality. Tells kids that you get both of us, you have a chance to, you don't have to choose, and it reduces conflicts by easing the burden on families and courts. And then I said that Tennessee can lead by valuing both parents' roles and creating positive childhood experiences and passing presumptive 50-50 custody for children, which I have served 300 daily, is for every child who deserves a full balanced story in their lives. And that's what I was talking about and everything. And so I think that it's very important that we focus on the children, looking at what's creates positive child experiences. We oftentimes hear about the adverse child experiences, but we don't talk much about what creates the positive child experiences. And so when you think about it from my professional lens as an educator, when we see those parents that are actually working together and have time together with their children, then it creates an environment where the children can thrive. And I know that everybody wants our children to thrive in our community. And we know that when you have both parents equally involved in their lives, it's very important. And then, as the gentleman said, when you think about basically the shared visitation, I don't know if people really understand, that's basically 4 days a month that you have to actually work with your children. And I don't know if that's really a great number to actually support a child 4 days in a month. And I think, we get the notion of every other weekend, but there's only 4 days a month that you actually work with your children and everything. So I think we need to really focus on providing positive child experiences for our children.
All right. Thank you. And to the lawyer, I can't remember your name.
I'm an Uber driver, not a lawyer, but.
Oh. All right. I'm going to ask you anyway. Are you familiar with the process for developing parenting plans?
There's several
And do you
different.
have an opinion about how this would impact that process?
There's several options. They could do like a week on, a week off. I know there's a couple in the audience here that does a 5-5-2-2 plan. There's a bunch of different options, and that's something that's pretty much determined between the judge and the two parents to figure out what's. But I think the most important thing is to say, wait a minute, the child needs both influences. Now we need to figure out how to make it work, and that's why I said it needs to be about the child. The parents need to be able to figure out how to make that schedule work.
All right. Thank you. Thank you, Mr. Chairman.
Thank you, sir. Representative Garrett, you're next on the list.
Thank you, Mr. Chairman. I move for us to go back into session.
Very good. Any objection? Seeing none. All those in favor of going back to session, say aye. Aye. Opposed, say no. Ayes have it. Thank you all for being here today. We're back on the bill of the sponsor. So we really appreciate your time. Thank you so much. Members, any questions for Representative Parkinson? Representative Garrett, you recognize?
Thank you, Mr. Chairman. I don't know how much time we have, but I've got quite a bit to address on this particular piece of legislation. I've talked to the sponsor. We've already had some heated discussions, I would say, maybe on my end more than on his. Fair enough. On this particular piece of legislation, as the committee knows, I practice law. I've been a lawyer. I've done family law. I've done divorces. I've done mediations. I've done child custody issues for my entire career as a lawyer. And I have some grave concerns about this piece of legislation. Let me kind of describe why. We heard a lot there from the witnesses. One witness had a custody case in another state, had nothing to do with the laws of the state of Tennessee. And I'm sure what happened to him in Illinois was a lot different than what's happening here. We had one expert talk about shared parenting, and shared parenting is absolutely doesn't mean 50-50 as it relates to what shared parenting does. We already have shared parenting here. In fact, our statute, the lawyer with the Tennessee Bar Association's family laws practice said that right now we currently our judges are required to maximize the parenting time in a divorce setting for the parents. Let's not take the extreme cases, what that means, right? The ones that we're talking about being an abusive parent, that oftentimes the parents are the one abusing the children. And in this instance, for a 50-50, you're automatically giving them credit for being a 50% great parent. And although I don't agree too often with my friend from Knoxville, Representative Johnson, I absolutely 100% agree with her statement. She asked to one of the folks that testified earlier is that you're elevating the importance of the parent rather than elevating, which the Tennessee does currently, the best interest of our children. And so when we have something that's not the extreme, which in this role that we play, sometimes we do things for the extreme to make a point. I'm not going to go there. I'm simply going to say, what if you have an absent father? What if you have an absent mother that cannot determine where the next visit for the pediatrician's office, what appointment they have for their annual well exam, can't even name their pediatrician. That's many things I do in the deposition with someone is ask these very basic information about what parents typically do. And when that parent can't answer those things, when they can't determine and have a relationship with their parent, they don't go to their Little League baseball games, they don't go to their dance recitals, they don't show up. These are all factors that we consider on whether or not they're a good parent, right? All of us can be fathers for the most part. All of us can be mothers for the most parts, but it's harder. It's a challenge to be a mom and to be a dad. There's a difference. And so when we tell a judge that they've got to give someone that does not go to any baseball games, that does not go to any dance recitals, that doesn't care what their kids are, doesn't even know what their grades are when their report cards come out, we're going to give that parent automatic 50%. Boy, you're halfway there. You are halfway a great parent. And we're making these judges make that determination on the onset. And that's bad policy, Representative Parkinson. That's what this bill is going to create. One other thing that it's going to do is that typically the major things that people fight about, and unfortunately, these are some of the worst circumstances that you can possibly have when people want to divorce and basically dissolve a family. Then you're going to have two households, two places to go, right? That's a terrible position to be in. 80 to 85, maybe even more % of these cases, divorces and child custody cases settle. That's historical, right? They go and settle. The parents find a way to resolve their differences for the best interest of their children. Most of the time, not for themselves. What we're going to create now is that when you run the child support calculator, that's based upon income and that's based upon days spent with the child. It's always, 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 always going to be ran on a 50-50 basis if this bill passes. That is a substantial difference in what a child support order would be based upon a 50-50 scenario rather than what is practical, what a judge can determine on the facts before them, on the cases that go to trial. By the way, they're the worst cases. These are the cases the parents cannot agree. The parents don't know how to parent. Their children are desperate for their parents just to be parents. They're the ones going to trial. The worst cases you can think of is what our judges have to determine. And we're going to say both of them are equal footing. I would go further to echo my friend from Knoxville and say they should start at 0%. They should come busting down through the courtroom door and say to that judge how good of a parent they are, that I want 100%, but they got to start at 0. They don't start at 50%. That is impossible. That's detrimental, I think, to giving the discretion the judges need to view each case separately. We heard 5 or 6 different stories about the folks that testified. Each case is different, each case is specific, and each case is unique. And that judge has to have the tools to not start at a 50% for each parent when one parent doesn't even know the middle name of their kids, much less in an abusive relationship. That's what this piece of legislation, Representative Parkinson, is going to do. One thing that also concerns me, and then I'll be glad to hear from others. I know I've taken a lot of the time, and I appreciate the chairman giving me a long leash on this, is that to modify a parenting plan, you've got to prove a material change in circumstance. You are about to do that with this bill. Every single custody order or permanent parenting plan that's in place, this statute is going to allow the parent that has the children less to come back to court and say, I get 50%. So we're going to open up the floodgates for folks to come back, relitigate their cases, because now they see a statute that could allow them and guarantee them 50%, whether or not they care to see their children or not. That's what this piece of legislation does, committee. That's what this piece of legislation bothers me. That this piece of legislation is bad policy, and that's why I cannot vote for it. And I hope you all see that this legislation is not good for the best interest of our children, not the best interest of their parents. Thank you, Mr. Chairman.
Mr. Chair, can I respond?
Representative Parkinson, you recognize.
Thank you, sir. And Chairman Garrett, I truly appreciate your experience and your insight and you know the things that you're bringing up. I think it's important to note that we're not putting parents on equal footing here. We're simply setting a starting place. All of the scenarios that you spoke of is that evidence that is absent based on the presumption. So again, let me go back to the definition of the presumption. It is a presumption, a rebuttable presumption. That means this is where we start, absent the evidence. So if there's evidence that this father is abusive or this other parent is abusive, right? That removes the presumption. Now, and that gives the judge the full discretion to grant that living arrangement or whatever the judge decides to do for that child, right? The other thing is this: I'm not with this legislation. We're not expecting 100% 50-50 outcomes. That's not realistic for us. That's not even what we're attempting to do. All we are attempting to do is set a starting place. Let me give you an example of what it could. Well, we've heard a lot of testimony based on current law. And it wasn't great testimony. But what happens if it is an elected official fighting for custody of his child? And we know we might not have the specific relationship or be, personal pals with a judge, but it's not far-fetched that the judge could lean that way under current law right now, right? Because we know that it is a fact in most cases today that the judge tends to lean towards the mother, right? And that's fine. And under this law, the judge can still deviate from that center based on, but we're asking for here, present the evidence. And one thing that I hope that we'll all consider and take exception for is the majority of fathers want to be in the lives of their children. The majority, in fact, I would say the overwhelming majority. But we are in here painting a picture of non-custodial parents as if they are abusers based on an accusation. But when the judge hears the evidence of that abuse, the judge has the full discretion to move from the center. So this is not a bill that I think that and every testimony is incredibly important. Let me preface with this. And to the young lady and her daughter, my heart goes out to you, and we definitely don't want those situations. But that is not the majority of situations. That is not the majority. 20% of marriages end in divorce based on abuse. 80% don't. Parenting plans, when couples go through a divorce, they're the only ones that have to, for the most part, present a parenting plan. It's the divorces. When they go through the divorce, the judge can absolutely accept that parenting plan under this legislation. He can accept it, whatever they decide. And so in cases where they are not married, you had a child out of wedlock, and these individuals are coming before the judge starts in the middle, and he can deviate as soon as they tell him what's going on in these households. So I apologize if I'm not fully, understanding the argument here. So, and I apologize.
Thanks, sir. Leader Lambert, I have you on the list next.
Move previous question.
We're good. Previous question has been called. Any objection? All right, seeing none. Members, looks like we're ready to vote to send House Bill 1131 to.
Can I have a closing statement, Mr. Chair?
Counter rules. You just did. Members, all those in favor of moving House Bill 1131 as amended to counter rules, vote yes. Opposed, vote no. All right, members, everybody voted. Any member wish to change their vote? All right. Madam Clerk, take the vote.
Mr. Chair, you have 3 ayes, 16 noes, and 2 present not voting.
House Bill 1131 fails.
Thank you. Thank you, Mr. Chair and Mr. Committee. Can we hear that last one so I can get out of here, Mr. Chair?
Members, without objection, if we could take up from the Hill as well, House Bill 361 by Representative Parkinson. And we've adopted this amendment. We'd started this bill, members. It's It's on the Hill. It's House Bill 361, members. I'm sorry. I don't have the item number listed here. What's the item number? It'll be item 10 then. I apologize. Item 10. Members, item 10, House Bill 361. There's a motion. There's a second. We'd started this bill previously. Yesterday, we'd adopted the amendment, House Amendment 4221, members. So with that said, Representative Parkinson, you're properly recognized.
Thank you, Mr. Chair. This is the bill we discussed yesterday that simply clears up the language in the code that says any judges hearing domestic violence cases, assault cases, they can issue an order of protection.
We're good. Members, any questions for the sponsor? All right, seeing no question's been called. Any objections to the question? All right, seeing none. Members, we're going to be voting to send House Bill 361 as amended to calendar and rules. All those in favor, vote aye. Opposed, vote no. So every member voted in. Member like to change the vote? All right, Madam Clerk, if you take the vote, please.
Mr. Chair, you have 20 ayes, 0 noes, and 0 present not voting.
Very good, members. House Bill 361 as amended is moving to calendar rules.
Thank you, Mr. Chair, and thank you, committee. Appreciate you.
All right, members, we're going to go to item 16, which is House Bill 491 by Chairman Farmer. We have an amendment on that bill, 3999. We have a motion and a section. Any objections to the amendment? All those in favor of adding Amendment 399 to House Bill 491, please say aye.
Aye.
All right, Mr. Speaker, Mr. Chairman.
Thank you, ma'am.
There we go.
Members, all we're doing here, we created an opioid abatement council. We've been receiving settlement funds, carrying this for the Attorney General's office. We're going to be receiving another $120-ish million over the next short bit. That's, well, actually, as a matter of fact, it's ready to be received. So this bill would allow us to receive those funds and then disperse those to our locales and municipalities that have been hit hard by the opioid epidemic. So with that explanation, I'd move passage. Thank you.
All right, question has been called. Any objection to the question? All right, members, we're now voting on House Bill 491 as amended to go to Finance, Ways and Means. All those in favor vote yes. All those opposed vote no. Has every member voted? Does anyone want to change their vote? Madam Clerk, please take the roll.
Madam Chair, you have 21 ayes, 0 noes, and 0 present not voting.
All right, thank you. House Bill 491 as amended goes to Finance, Ways and Means. Now we are on House Bill 492. We have an amendment on that bill as well, 3777. Motion second. All those in favor of adding Amendment 377 to House Bill 492, say aye.
Aye.
Those opposed, say no. Ayes have it. It's amended.
All right, thank you. Members, what this does allows for reasonable attorney's fees and litigation expenses with regards to grandparent visitation cases. So that's what it does. I'll move passage.
All right, members, any objection to previous question? All right, members, we're now voting on House Bill 492 as amended by 377. It's going to go to calendar and rules. All those in favor vote yes. All those opposed vote no. Has everyone voted? Does anyone want to change their vote? Madam Clerk, please take the vote.
Madam Chair, you have 19 ayes, 2 noes, and 0 present not voting.
All right, House Bill 492 as amended goes to calendar and rules. Okay, now we're on item 32, House Bill 1180 by Chairman Farmer. We have an amendment to that, 6060. All right, all members, if there is no objection to adding Amendment 6060 to House Bill 1180, all those in favor say aye.
Aye.
Those opposed say no. All right, amendment is added to the bill. Chairman Farmer, would you like to address your?
Yes, members, what this does, this is actually a great piece of legislation. What it allows for is folks who want to adopt children. There's certain jurisdictions in the state of Tennessee that wants to charge an additional filing fee for if you're trying to adopt more than one child. So this will allow that you just pay one, if you just have to pay one filing fee, and then you can adopt, if you want to adopt more than one child at a time. So I think this is a step in the right direction. So I'll move passage.
Hang on just a moment. Leader Lambert.
Mr. Chairman, after that statement, I'm wondering, we just passed 3 other bills of yours. Were those not so good? This one's the only good one?
Well, it got me excited thinking about children getting adopted, Leader.
I love it. I love it. Let's do it. Pass it out.
All right, the question's been called. Members, any objection to the question? All right, we're now voting on House Bill 1180 as amended to go to calendar and rules. All those in favor vote aye. Those opposed vote no. Has every member voted? Does anyone want to change their vote? Madam Clerk, please take the roll. Or the vote.
Madam Chair, you have 19 ayes, 1 no, and 1 present not voting.
All right, thank you. So House Bill 1180 as amended goes to calendar and rules. All right, now members, we're on item 66. It's House Bill 486. We have an amendment on that. It's 5357. All right, any objection to adding amendment House Bill 486? All those in favor say aye. Aye. Those opposed say no. The ayes have it. The amendment is adopted. Chairman Farmer, would you like to speak about your bill?
Yes, members, this just would simply add, if passed and adopted, would add 5 additional assistant public defender positions in the state.
Any objection to the question? Any opposed? All right. Members, we're going to vote on House Bill 486 as amended, going to Finance, Ways and Means. Please vote yes or vote no. Has everybody voted? Does anyone wish to change their vote? Madam Clerk, will you please take the vote?
Madam Chair, you have 21 ayes, 0 noes, and 0 present not voting.
All right. House Bill 486 as amended goes to Finance, Ways and Means. Next, we're moving to, next we're moving to item 67. That is House Bill 487. We have an amendment on that. It's 5430. All right, members, we're now voting on the adding that amendment to House Bill 487. All those in favor say aye.
Aye.
Those opposed say no. All right, that amendment is added. Chairman Farmer, would you like to speak about your bill?
Members, the court clerks brought me this bill. What they want to do, they want to adopt an additional $2 assessment on their civil and criminal cases to help with their educational and the software and things that they use in the courts. It hadn't been raised in about 20 years. So I think this would be $2, an additional $2 assessed on civil and criminal cases. And this would help them get to where they need to be more efficient. I move passage.
Any objection to the question? All right, members, we're now going to be voting on House Bill 487 as amended, going to Finance, Ways and Means. All those in favor vote aye. Those opposed vote no. Has every member voted? Does anyone wish to change their vote? Madam Clerk, please take the vote.
Madam Chair, you have 21 ayes, 0 noes, and 0 present not voting.
All right, House Bill 487 as amended goes to Finance, Ways and Means. Next, we're moving to item 68. That is House Bill 1127. We have several amendments. We need to, so we have Amendment 6898. That would.
Yep. If we could adopt 6898, then I have an untimely filed amendment, which would then adjust 6898, which rewrites
So
the bill.
let's adopt 6898. All those in favor say aye. Aye. Those opposed say no. Okay, we have adopted that amendment. Now we need to consider Amendment 7309.
Yes.
All those in favor of a motion to consider Amendment 7309 say aye. Aye. Those opposed say no. All right, now we're going to adopt Amendment 7309 to House Bill 1127. All those in favor say aye. Aye. Those opposed say no. Okay. Also, the ayes have it. That is added. All right. You don't want?
Can I make a motion to roll those into one, please?
Yes. Yes.
And I will explain.
All right. Without objection, we'd like to roll both of those amendments into one. And then once we do that, we can explain the bill. Do I have a motion? Do I have a second? Thank you. All those in favor of rolling both of those amendments into one, say aye. Those opposed, say no. The ayes have it. It's done. Thank you, Chairman Farmer. Would you like to explain your bill?
Yes, I will. Members, what this does, right now, foreclosure notices are required to be ran 3 times in our newspapers. And every time that is ran, there's a cost that's passed through to a person, an individual that's being foreclosed on. Obviously, that type of situation, they're already behind the 8 ball. So what would happen here is I would like to, initially my bill, it brought it down to where it run 2 times and we kind of phase this notices in the paper out and kind of go online. But as I was working with folks, I want to take the phase out away. And what my latest untimely amendment does is it just simply brings a requirement of 3 times ran in the paper down to 2, just a straight 2. So there's no phase out, no nothing there. So in hopes that we'll be saving costs to the consumers that are unfortunately going through a foreclosure process. So that's what it does. I'll be happy to answer any questions.
Chairman Doggett, you're recognized.
Thank you very much, Madam Chair. And that was my question, just for clarification, was that the bill as amended now just moves it from 3 to 2 postings on a foreclosure notice. We don't have the phase out. There's not any online publishing requirements on a third party site or anything of that nature.
That is my understanding.
Thank you very much.
Chairman Eldridge, you're recognized.
Thank you, Madam Chair. And to Chairman Farmer, I want to thank him for that amendment. Our area still has a lot of small papers up there, about 5, 6 that I know of, and that people still rely on to get local news. And that, to me, a notice like that is very much local. So I appreciate you doing that. Thank you, sir.
Chairman Todd.
For clarification, question that was previously asked about rolling these 2 amendments into one. I see the second amendment, if I'm seeing the right one on dashboard, just deletes and replaces one section. So the rest of the requirements in that first amendment we adopted still has the third-party websites. Okay, I just want to make sure you're getting on a website somewhere and folks can see that more broadly.
Chairman Farmer.
That's correct.
Chairman Doggett.
Now I'm confused.
I got it.
All right.
So there is currently a third-party website that once you purchase the foreclosure ad in the paper, once that's purchased, then the papers will then submit that notice to a third-party. It's already set up. This has been happening. So it's also on a third-party site as well currently. Once you purchase that foreclosure notice, like if a bank does that, then the papers will then go and put it on that third-party site. So it is online as well once you purchase the foreclosure notice from the papers. So,
Chairman.
Thank you. In current law, it's 3 postings in the paper and it's online posting, or is this a new requirement?
Chairman Farmer.
Yes, and it's online because of what I just said. Because it's 3, you have to buy 3 in a paper. I'm just saying, hey, you just have to buy 2, but they're going to go ahead and they're going to put it on that third party site, because you purchased the 2 or 1, anyways. It's going to go on there automatically. They're going to automatically put it on there.
Okay. Okay. Thank you.
Representative Hardaway.
Thank you. What does it do in terms of the total number of days that it will be published?
Nothing.
So that doesn't change at all?
No.
All right. And that is?
Are you finished, Representative?
No, I thought he was going to fill in the blank for a total number of days.
Very good. And Very good. Yeah, I need, there's a technical, I was just, legal notified me that there was a technical error, or, which was supposed to be an and in the late filed amendment. It was a one sentence amendment that I filed that just said 2 postings. The or in there should have been an and. So if
Okay.
we could just strike
So do we
or.
have a motion then to change that
The
technical?
or to an and.
Second.
All right, all those in favor of verbal motion, technical, to change it from or to and? All in favor of this verbal amendment, please say aye. Those opposed, say no. And now, do we have a motion to roll them all into one? Without objection, please say aye. Good deal. Let's go. All right. Representative Hardaway, did you have any other follow-ups?
Number of days?
30 days.
30.
30.
Representative Towns?
Another question, I'm moving. Question on the bill. Question on the bill?
Any objection to question on the bill? All those in, all right, seeing no objection, let's vote on House Bill 1127 as amended. All those in favor vote aye. Those opposed vote no. Has everybody voted? Does anybody wish to change their vote? Madam Clerk, please take the vote.
Madam Chair, you have 20 ayes, 1 no, and 0 present not voting.
All right, members, House Bill 1127 as amended goes to calendar and rules. Thank goodness.
And members and folks, I forgot to announce, should have done this earlier. Item 37 to announce. I had an announcement I should have made at the beginning of committee. Item 37, House Bill 856 by Representative Capley. He's asked for that to be taken off notice. So House Bill 856 is off notice. All right. Members, if we could, thank you for bearing with all of that. Item 43, House Bill 1256. And you got a motion and a second by Chairman Doggett. And I see House Amendment 6795. Members?
No, sir. I actually have a late filed amendment, Mr. Chairman.
Members, do I have a motion and a second to take up an untimely filed amendment? You do. Motion say, all in favor say aye. Aye. Opposed say no. Ayes have it. And what's that drafting number, Chairman?
7308. It should be on your dashboard.
Members, it should be on the dashboard. House Amendment 7308. Any objection to adopting House Amendment 7308 to House Bill 1256? All right, seeing none, all those in favor say aye. Aye. Opposed say no. Ayes have it. All right, Chairman Doggett, you are properly recognized, sir.
Thank you, Mr. Chairman. This deals with failure to appears and also for entering this information into NCIC. The change, the reason for the late filed amendment was that we changed it from one day to the end of the next business day as a requirement on the clerks and the judges.
Very good. Members, any questions for Chairman Doggett? All right, seeing none, we ready to vote? Any objection to the question? All right, members, looks like we're ready to vote to send House Bill 1256 as amended to calendar and rules. All those in favor vote yes. Opposed vote no. Does everyone remember voting? Anybody like to change the vote? All right, members. Very good. Madam Clerk, if you would please take the vote.
Mr. Chair, you have 21 ayes, 0 noes, and 0 present not voting.
Very good, members. House Bill 1256 as amended is moving to calendar and rules. Very good. And that brings us to item 42, House Bill 576. By Chairman Doggett. So you got a motion and a second. Members, see House Amendment 6400.
Yes, sir. That's what I wish to proceed with.
Okay, got a motion and a second. Anyone opposed to adopting House Amendment 6400 to House Bill 576? All right, seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. All right, we're on the bill as amended. Chairman Doggett, I know there's some testimony on this one, I believe, so I'll let you handle that however you'd like.
We can go ahead and go out of session here from testimony if it's okay with you, Mr. Chairman.
Sounds good. Members, any objection to that? All right, seeing none. Out of session. One moment. All right, if we could, we have a decent sized list here. So if we would, how about, let's do Jimmy Music, Steve Crump, or whoever, and Mike Donovan, Courtney Lynch. Either one of you all want to come up, or all three, either however you want to handle it. And Rick Nagel. We'll see how many we got here. We might be able to pull everybody up at once. Okay, very good. I'll say, hey, Nathan Ridley, sir, if you'd come on up here, and then Mr. Will Rainey, and then Bill Nolan, if you guys want to come on up, and y'all, I believe y'all can sit on the right-hand side there, and we can. Mr. Music, we'll start with you, and we'll just kind of work our way from my left to the right there. And you know the drill, sir.
Good afternoon, Chairman and committee. You scared me earlier. You called Mr. Music on a parenting plan bill, and that is well outside my expertise. So I'm here. So I represent the sheriffs and chiefs of police. And I don't know if there was an initial explanation of the bill. This is the one that sets up a board of professional bail bondsmen that is 7 members that consist of 3 bondsmen and then a judge, a DA, a clerk, and a sheriff. Just wanted to start by saying, you know, this came from several years coming when Senator Hale had gone around the state on this issue. And then last summer, the chiefs, the sheriffs, and the DAs got together, and we talked about several issues in this vein. This was one of the items that was brought up as a real need, and the genesis of it was often from when you have a bondsman that maybe was disciplined or reprimanded by a judge in one judicial district, but they practice in multiple, and sheriffs trying to communicate that amongst each other, the judges not knowing that as well. And so the idea was a central location that could handle complaints, both from the citizenry, the customers themselves, and then a way for that communication to go down. Our intention in this was to absolutely not negatively impact legitimate operators in Tennessee. With my sheriff hat on, I will tell you that, and we said this earlier on the Senate side, that for us, we know that there isn't a non-government entity that we work with and partner with that does more to help sheriffs than good bail bondsmen. And so I'm happy to answer any questions that you may have and stand ready for those. Thank you.
Thank you. Mr. Crump, you recognized.
Thank you. Thank you, Mr. Chairman and committee. My name is Stephen Crump. I'm the Executive Director of the Tennessee District Attorneys General Conference, and we are here in support of this bill. I won't go back through the things that Mr. Music just went through, specifically relating to our ability to know about bondsmen from judicial district to judicial district. That's been a long-term concern of Tennessee's district attorneys. The vast majority of bondsmen in the state operate very well. The ones that don't, we don't have any way of knowing if they move into our judicial districts. This would eliminate much of that, if not all of that issue. Secondly, obviously, we want locals to have input on who does bonding in the committee or in the courts rather. And we believe that this bill does a good job of balancing both the need for independent oversight on an outside basis with local control with our judges. The language that you see in this bill will be significant in that we believe it actually expands the discretion of the judges to get to more conduct that may be bothersome to them or may be harmful or detrimental, not just to the system, but to the bondsman's clients. And then lastly, we're fortunate in that we've already had an operation like this where we have worked in conjunction with local judges as well as an agency, a board under the Department of Commerce and Insurance. We currently regulate the maintenance and upkeep of cemeteries across the state. And I, as a DA, when I was elected, I was fortunate to be elected by the people twice as district attorney. We had 3 cases in which I worked with the Department of Commerce and Insurance, a specific board with cemetery maintenance, to help the troublesome cemeteries be policed and obviously take care of the ones that didn't. This system will work. It is working in Tennessee now in a different area, and we wholeheartedly support its passage by this committee.
Very good, sir. You recognize.
You just introduce yourself. And,
All right, Mr. Chairman, thank you very much, and members of the committee. Thank you for the opportunity to testify today regarding House Bill 576, which seeks to reform the regulation of the bail bond industry. My name is Rick Nagel. I represent Tennessee Bonding Company, and I'm here to express my support for this bill, which aims to enhance oversight, accountability, and transparency within the bail system. Any agent in the room who supports the bill, please stand. One of the most significant aspects of this bill is the establishment of the Board of Professional Bondsmen under the Department of Commerce and Insurance. This move centralizes oversight and ensures consistent regulation of bondsmen across the state. Transferring the authority to suspend, revoke, or deny licensure from the courts to the board will promote uniformity and fairness in disciplinary actions while maintaining judicial oversight within local jurisdictions. Requiring bondsmen to notify the board rather than individual courts of their arrest within 72 hours is a vital improvement. This change, along with the requirement that courts report disciplinary actions to the board, will create a more efficient and transparent system for tracking misconduct. Additionally, the mandate for biannual filings with both the board and the court clerks enhances regulatory compliance and ensures accurate record keeping. By prohibiting professional bondsmen from simultaneously owning and operating a GPS monitoring company, this legislation addresses potential conflicts of interest and safeguards against unethical business practices. The bill also eliminates the ability of a bondsman to withdraw from a bond due to breach of a contract, reducing opportunities for unfair treatment of defendants. Importantly, House Bill 576 maintains the authority of courts to restrict bondsmen within their jurisdictions while ensuring that disciplinary actions are communicated to the board for further review. The bill also allows district attorneys to file complaints against bondsmen for misconduct, ensuring an additional layer of oversight from law enforcement. In closing, this legislation represents a critical step forward in reforming the bail bond industry. By creating a dedicated regulatory body, improving accountability measures, and ensuring fair and ethical practices, House Bill 576 will enhance public trust and promote a more equitable justice system. I urge the committee to support this bill and move it forward for full legislative consideration. Thank you so much for your time.
Thank you, sir. Mr. Ridley, you're recognized.
Thank you, Mr. Chairman, members of the committee. We're grateful for the opportunity to speak to you, and we're very, very sensitive that y'all have been sitting on the dais for 3.5 hours, so we'll be bright, brief, and gone. I'm Nathan Ridley. I'm pleased to represent the Tennessee Association of Professional Bail Bond Agents. Y'all all know that Tennessee has a constitutional right to bail in Article 1, Section 15 of our Constitution that's been there since 1796. It's an important check on the authority of the executive, and it's been regulated with guardrails set by the General Assembly by our trial court judges since 1796. This bill, in the interest of brevity, this bill establishes 2 regulators for our bail agents. 2 regulators. You can be on a list from the department. The judge may approve you if you're on that list. If you're not on the list, the bill does not speak to whether or not the judge may approve you. With 2 regulators, inevitably, there's going to be conflict, and there's not a resolution process in this bill to do that. The board itself is composed of 7 members. There are 3 agents, but if you look at other regulatory boards that y'all have established for different occupational groups, almost all of them are regulated by members of the profession. Almost all of them with overwhelming majorities, whether you look at accountants or pharmacists or lawyers or doctors. This one's curious in that regard. The members have 6-year terms. One member has a 7-year term for the initial rotation. That's a long time. The board's going to meet quarterly. The lawyers in the room know that court's held every day in our 95 courthouses, whether it's General Sessions Court or the circuit courts, right in the circuit. The judges are responsive to our agents. It's what they do. They are our regulator. Word travels fast in the judicial system. If an agent has misbehaved, I promise you, the judicial district next door, that judge will know.
Thank you, sir. Okay, your 2 minutes up.
Thank you.
You're recognized. Mr. Rainey.
Thank you.
Introduce yourself. You got 2 minutes.
My name is William Rainey. I'm the Vice President of the Tennessee Association of Professional Bail Agents. And good afternoon, Chairman and committee members. I began my career in the bail bond industry in 1999 and opened my own bail bond company in 2006. My base of operations is located in Memphis. I am currently approved to write bail in 14 counties in West Tennessee. I say the following with the utmost due respect to the sponsor and his good intentions. House Bill 576 is flawed in a number of ways. In an attempt to maintain the ever important discretion of local presiding judges and their respective judicial districts, the language of the bill as written creates a hybridized distribution of authority between all judges presiding over criminal matters and a professional bail bondsman licensing board comprised of several appointed members from various facets of the criminal justice system. This licensing board would be an additional office and infrastructure within the Department of Commerce and Insurance. This bill creates the potential for a bondsman to be approved to post bonds in one court, but prohibited from posting bonds in another court within the same judicial district and even within the same courthouse. Furthermore, the bill seeks to take away the current authority of the Tennessee Association of Professional Bail Agents to teach the continuing education class to every bondsman and bounty hunter in the state each year. I've attended 25 continuing education classes as a student and countless other classes as a board member of the Tennessee Association of Professional Bail Agents. While we always seek the knowledge and wisdom of people that work in the criminal justice system other than bail bond agents, it is important that the curriculum of the class be formulated and shaped by those within our industry. I would venture to say that the bail bond industry is the most unique of any in the world. Until someone has done this for a living for an extended period of time, they will struggle to answer a myriad of questions on a regular basis. This caption bill was amended at a point in time that has left very little time for contemplative thought on a variety of issues beyond the ones that I have already mentioned. I respectfully implore this committee to take the time to carefully consider this and give those that are most affected by this legislation a proverbial seat at the table. I'm happy to answer any questions that any of you have at this time. Thank you.
Thank you, sir. Mr. Nolan, you're recognized.
Mr. Chairman Farmer, I want to thank you for having us here today. Representative Doggett, I want to thank you for doing a fine job on coming up with this legislation. This is my 57th year. I've been either in the legislature or lobbying. When I first was elected in 1976, it took us 1 year to go through bail reform, a year. Three weeks ago, this caption bill came out, and this bill had 12 pages. The association and its agents don't let people get out of jail. They bring them back to jail so that the victims can have their days in court. I was really glad to hear the sheriffs say how hard they work with the bail bond industry. For the 30 years that I've worked for this industry, the sheriffs have been hand in hand. So I've been a little shocked about this session. I hope when this session's over, we can get back together. The bail bond industry returns 80,000 people a year. They do a good job. I bet there's not a lot of people in this room that have heard that bail agents have done a bad job, bad bail agents. We probably get a few more bounty hunters that get in trouble than ever will bail agents that will get in trouble. The most unique thing about this is that this bail bond industry that we have, this association in Tennessee, it is different than any association we have in the state of Tennessee. What's different about this is we did not set up a regular organization. We set up an organization that was run itself. We privatized the Bail Bond Industries Association. What this does, this brings it back to a multi-million-dollar government agency that's what we typically saw in Tennessee. You put together an association, you start charging the state money, and then that association goes on, and every year that amount builds up and up and up. We deal with sheriffs, we deal with judges, we deal with clerks, we deal with everybody who is in the judicial system, and we're the only one that charges no money to the state of Tennessee. Those 80,000 people, those cases that we talk about, there's no money charged to the state of Tennessee for that. These people have a business that has been going on for 700 years. 700 years we've had bail bonds. When we came across the river, or is it the pond?
Thank you, Mr. Nolan. We're
That's your time's up, sir. We'll have plenty of time for questions, though. Thank you so much. 2 minutes is up there.
Thank
It's a little over 2 minutes, though. Trying to get a good stop for you, start and stop us part for you. Members, any questions for our guests? Any questions? All right. Seeing none. Representative Towns, you have a question? Okay. You are properly recognized.
Mr. Chairman, thank you all. Thank all of y'all for coming and presenting. I've gotten calls from back home as it relates to this particular bill. I want you all to clear something up for me. What has been shared with me just recently is that this particular legislation possibly puts the squeeze on small businesses, small bail bond businesses. Is that true, or what does that do? Whoever wants to speak to that, I'd appreciate it. Make it clear for me, please.
We've been running a situation where you have two types of industries here. You have an insurance industry that is made up of a very deep pocket association. Half of my agents are insurance backed, half of my agents are mom and pop backed. That's your local people. What I'm concerned about is that they're going to come in here, they're going to have one commissioner, and he's going to pick every bail agent across this state, not the judges. One commissioner is going to pick the bail agents across this state. What I worry about is you'll set up one office in Nashville, Tennessee. They'll have 5 or 6 bail agents across this state. The insurance companies will, and the mom and pop stores will not have the deep pockets to compete with those people. And I wonder, the judge knows these people. He knows where they are. He knows who they are. I wonder how in the world you're going to pick up skips, those 80,000 people that the bail bond industry picks up. How are you going to pick that up running an office from Nashville? You're going to have 5 or 6 people across the state writing bonds. I get the writing bonds, but what I'm concerned about is how they're going to pick up those people who skip, those people who cause harm to the people of the state of Tennessee. The process that we are doing works well now. There's very few of y'all, like I said earlier, that have heard about a bail bond agent that's been a criminal, that's been a problem.
So how many do we
President
have
Towns,
now? How many?
You recognize.
Thank you, sir. Thank you, sir, Mr. Chairman. That are performing this duty now. How many?
We have about 300 companies and about 3,000 agents in the state of Tennessee.
Okay, but the commissioner you said would be one commissioner centralized. How many do we
Under this
have?
law.
How many do we have now that would be doing what one commissioner would be doing?
Well, if I look at other states that have done things like this, you find the attrition starts slow and then it wears down the small people. They eventually go and have to join in with the insurance company. So
I want to go to this side if you don't mind, Mr. Chairman.
Okay, just be courteous of time. We're running, there. So
Okay.
just be courteous of other members as well in case they have questions. Thank you.
Just real fast. I don't see anything in the bill, any of the verbiage that hurts small businesses. That's all I wanted to represent.
Representative Towns, anything else? You good?
No, I thought.
Okay. Mr. Music, did you have a response or something?
Yes, thank you. So I don't understand how it would allow a board in Nashville to dictate what's going on everywhere, because essentially when you're talking about the minimum qualifications, that board, think of it like the post commission is for law enforcement. The standards that you all set, the post commission ensures that every applicant does those. And that's how they get commission. At the local level, our guys, the sheriffs and chiefs, they can have additional hiring criteria or whatever they want, but the minimum, the state ensures that we've met that process. And that's really what we're talking about, is because once that officer is commissioned, yes, he could technically practice and be a law enforcement officer anywhere in the state, but he would still have to be hired and approved by someone at the local level to do that. That's really the system that I think that we're talking about here, is just having a state board that is going to set those minimums or enforce those minimums that you all have set that are not changed by this bill, and then put the entire state on notice that this particular agent, or for us as in the law enforcement, this officer has met those standards, and so they can be hired and work. It doesn't mean that the Shelby County Sheriff's Office has to hire Jimmy Music. It just means that I'm eligible as a commissioned officer.
Thank you.
Any follow-up? You good? Representative Johnson, I had you next on the list. Do you have any questions? Okay, fair enough. Vice Chair Davis?
I make a motion that we go back in session.
Any objection? All right, seeing none. Thank you all for being here. All right, members, we're back in session. Do we have any questions for Chairman Doggett on the bill? All right, seeing none, we ready to vote? All right, looks like we are. Members, all those in favor of moving House Bill 576 as amended to government operations, vote aye. Those opposed, vote no. Has everyone voted? Anyone? Let's change their vote. Okay, got it. All right, Madam Clerk, take vote.
Mr. Chair, you have 14 ayes, 3 noes, 1 present not voting.
House Bill 576 as amended is moving to government operations. All right, members, I believe that brings us to the end of today's calendar. So I would, Leader Labyrinth.
Mr. Chairman, I think you've done a fantastic job this year. All of us have truly enjoyed serving with you. And at this point, I would move to adjourn.
Very good. Members, we're going to be adjourned, subject to the call of chair.